Instead of future instant random.
Sir, court officer.
ಹೇಳಿ ಸರ್.
Sir, ಏನಿಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ ಕರಿಬೇಕಾರೆ ಮೈಕ್ ಹತ್ರ ಬಂದಾಗ ಒಂದ್ಸಾರಿ ಹೇಳಿ ಸರ್.
ಆಯ್ತು ಸರ್. ಆಯ್ತು.
ಸಾಹೇಬ್ರ ಹತ್ರ ಬಂದಾಗ ನೀವು ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ ನಮ್ಗೆ ಕೇಳಿಸ್ಬಿಡುತ್ತೆ.
ಸರಿ ಸರಿ ಆಯ್ತು.
ಓಕೆ ಸರ್.
Fresh matters if you come Monday or Tuesday. From the time that you want it on Tuesday. Interim order idreno construction Monday.
Because the matters and they are forming the road, they should be property.
Date code track.
Dated on 4/9. Date 4/9.
4/9 is the date. That is Monday.
One day is there, because what she was ordered to be listed today, I moved a memo, but for the 2 days, they will complete the process at the end of the list.
What are they doing?
Because there is a more formation is going on the scheduled property. We will show the out of the DA, Taluk Panchayat, Evo order is tagged in my Khata. If everything is in my name, they started road formation in my property. See, that process has been going on right here.
Road formation without acquisition. End of the list. Which is the, which panchayat? Which panchayat?
Taluk Panchayat.
Which panchayat? Which taluk panchayat?
Yes.
Legal error. Serve it on Mr. Nagarajappa. Serve the petition on Mr. Nagarajappa. End of the list. Fresh matters. Monday or Tuesday it will come, 2 days. Why, Mr. Vinay? 2017 matter ಅಲ್ಲಿ ಇನ್ನೂ ಟೈಮ್ ಬೇಕು ಅಲ್ಲ 32 at the request of the council for the petitioner released on 3rd October. India interim order earlier granted is extended till next date of hearing. If arguments are not advanced on next date of hearing, the petitioner will be liable to dismiss the non-person. Thirty. ಹೇಳಿ. Submitted that the council for respond number 2 is unwell. Released on 27th September. Serial number? 42.
Malad, serial number 44.
Just a minute. Council for the petitioner has filed a memo dated 1/9/23. Signed by the council for the petitioner seeking permission to withdraw the above writ petition. Accepting the memo and the submission of the learned council for the petition, petition is dismissed as withdrawn. Yes?
But serial number 44, my lord, and for the respondent, my lords, 1 to 6. My lords, the council is a bit unwell, my lords, and we had requested the petitioner council also, and he's been informed, my lords. Week's time may be granted.
So at the request of the council for respond number 1 to 6, released on 8th September.
Much okay.
Well, wait.
Page number 8, serial number 47 to 50. Page number 9, serial number 51 to 54.
It's a baby property tax number. On the report has disposed on the petition. Since the election has been flashed. So the last time the submission was made before the report to mention extend this matter to take the same order of the of 1 to 954.
When it reaches, not at 10:30.
Page number 10. Page number 11.
16. You are appearing for. Ms. Soumya ji, 64. 64 out time vacant. Public interest. Time vacant. 64 on behalf of the council for the petitioner. Short accommodation is sought for, released on 8th September. 8th. Have you informed the petitioner? 2 weeks time for? And counsel for respond number 224 seeks for and is granted 2 weeks time finally to file a statement of objection, objections if any by 29th September, relist on 5th October.
Order serial number 1.
You will sought for permission to file fresh IAs.
Fresh area has been tried here.
Even there also you have a problem.
Twice I have produced the document. One is along with the amendment application.
Last time you filed, it had so many objections. Again, you have the same.
Your office attention is only that one along with the production of document and production of.
Rule of 23.
Twice they have raised the objection saying that twice I have produced.
Which annexure is produced twice?
Connection here, G, date. I have produced along with the amendment. I also have produced along with the production of documents in the list. I am not going to place this application production, right?
You produced it along with the amendment application also and IA 4 of 23 also. If the amendment application is allowed, this application is not required. The counsel for the petitioner submits that he does not wish to press IA 4 of 23. In view thereof, IA 4 of 23 stands dismissed. What about IA 3? Any objections? IA 3 of 23 has been filed to place on record certain additional facts and additional documents. Being of the opinion that the same would be required for effectively disposing the matter, the said application is allowed. Counsel for the petitioner to carry out the amendment and file amended petition on or before 21st. Read this objections on or before 21st. The counsel for respond number 4, 3, 4 Garo. Who will appear for 4?
3.
3 Nividila. You appear for them. You have to ask your authority to give. We are 3 jana party is onde ಒಂದು ವಕಾಲತ್ತು ಇನ್ನೆರಡು ವಕಾಲತ್ತಿಲ್ಲ. Let file ವಕಾಲತ್ತು. That counsel for respond number 3 and 4 seeks for 2 weeks time thereafter to file his additional statement of objection. Additional statement of objection to be filed on or before 6th October, relist on 10th October. After 12th October. After 12th, Andre, it will go to 25th October. Before 1st of October. We list on 30. We list on 26th of October. Petition copy, amended petition, everything. 2 sets you will have to give. And the counsel for respond number 2 seeks for and is granted 2 weeks time to produce the Vajpayee Town Housing Program document released on 25th September. Despite the order dated 11/8/23, none appears for the petitioner. Process fee has also not been paid. It appears that the petitioner is not interested in prosecuting the matter. The petition stands dismissed for non-prosecution. What have you filed?
This is the further directions where you direction number 497 The deputy secretary has to connect the inquiry. They are ensure.
So this is the inquiry report now.
Including the surrounding areas. But they want sister is going back.
You filed it along with the memo.
My lord, 10:20 they give the report. And just definitely.
So you should ask them to give it to you yesterday,
No, I
one
was-
day before the matter.
It was better yesterday. I got it concluded to a party. I'm very.
Learned counsel for Learned AGA submit that he has received the fresh inquiry report. He would be filing the same during the course of the day, a copy of which has already been furnished to the counsel for the petitioner. Counsel for the petitioner seeks for and is granted a week's time to go through the same and make the submission. Relist on 8th of September.
Serial number 5.
We got to cases with regard to enhanced power of the technology. More like general direction given by the court.
Yes.
So I need another 2 weeks time to get proper instruction.
What was submitted was that competitive tenders have been
My
invited.
lord, these were two software was actually implemented. My lord.
Yes.
Now there is been overall with regard to the entire system, where the ACs and DCs are being issued orders, that across all matters, it has to be considered and orders passed within a time limit. It's a very comprehensive issue. My lord. That's why I keep getting the target.
All the things you will have to re-enable.
So, before the next date of hearing, I'll just follow it up, because only letters they will react, telephone calls and make it. Ensure compliance by next date.
And AGA submits that para 5 of the order dated 20th June 2022 is under compliance, given 2 weeks' time. Further compliance will be reported. Released on 25th September at 2:30 p.m.
Serial number
ಮುಂಚೆ ಕೊಟ್ರೆ ಆಗತ್ತಲ್ಲ ಅನ್ಸ್ತೀನಿ.
Yes, my client was already out.
Just to, this becomes a post office, just to receive it and adjourn.
There was something I think, yes. It's part of it.
Counsel for the petitioner has filed an affidavit.
The matter is simple. Please take the, get around.
He has to go through it. He can go through it. Ma'am, affidavit along with a plan sanction, the same is taken on record.
Market red and blue below to me. I put up construction in the area marked with red pencil. Blue I keep vacant as required by my director.
For the purpose of widening of the road in future.
How do Tata after the part of that? Because the government orders very clear. During the road, during the plan.
You cannot sanction a plan, but you cannot ask for free. That is fine. To that extent, you have the authority. Now, if they submit a plan for the red portion, they should get a plan for the entire property FAR on the red portion.
Yes.
And blue will still be with them. If you want to acquire in a future point of time, you can acquire it in future point.
Tata has to make a respect of blue and red.
Yes.
If the road portion is in your land.
Your government order cannot override the statute. That is why it's all been. That is what Mr. Nadu has said. That's what he has said. You have come in the way of a person developing his own property. Why do you come in the way like this? All statutory authorities are supposed to be enabling authorities. not obstruction authority. You enable this. 17(2)(a). You dealt with 17(2)(a).
They were loaded different. In this case, there are very small, stated in this.
ನಿಮ್ಗೆ ಬೇಕಾ ಬೇಡ ಬೇಡ ಅಂದ್ರೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ನೀವು ಆಮೇಲೆ. Yogesh Naik seeks fund is granted a week's time to obtain instruction and make a submission. Released on 8th September. 9 ನೀವು ಒಬ್ಬರೇ ಬರ್ಬೋದು, ಅವರು ಬರಲ್ಲ. They'll submit a plan for the red. The kata will have to be made for the entire property. They'll submit a plan for the red portion, which you will have to sanction for the taking the FIR into entire property into account. You will have to give that. If tomorrow at some point of time you want to acquire or you don't want to acquire, we don't know. If you want to acquire before the next plan comes into place, you'll have to compensate. If in the next plan this road is not shown, then it goes. But if you want that land, you have to acquire. 69 has to be followed. ಅವರು ಕೊಟ್ಟಿದ್ದೀರಾ?
Received and denied the petition is paid in rate for the scope of the answer from
Proving account of mother. This is not introduced. It has to be filed after registration. Listen.
the BPMP is not issued separate renewable order.
You have produced the initial license? And counsel for the petitioner has filed a memo enclosing the receipt for having paid rentals for the premises in question. And counsel for respondent seeks for and is granted 2 weeks' time to obtain instructions, file a statement of objection and address arguments. Released on 15th. You have paid this after the matter was listed. You won't get any equity. Instruction was received, Mr. Bategoda? ಅವರು ಕೊಟ್ಟಿದ್ದೀರಾ? On 23/5, what was observed was you had made an application for modification. What happened to that? They had to make a submission. You again file ಮಾಡ್ತಾ ಇದ್ದೀರಾ? They don't need to notify you, Mr. This is online. You have to go check your status of the application. Or one in the Tambula, no red carpet. Everything is online. You will have to check the status of the application. If they say that there's something which is not uploaded, you'll have to do that. Otherwise, your petition itself is premature. If you don't give this. Let counsel for the respondent is filed a memo enclosing the note sheet of the order which has been uploaded on the online portal pertaining to the plan sanction application filed by the petitioner. On the basis of the same, he submits that several documents are yet to be uploaded by the petitioner. And as such, the said application could not be considered. And this submission is made in compliance with the order dated 23/5/2023. Learned counsel for the petitioner submits that he will look into the matter and seek instruction, make it submission released on 15th September.
The meantime, Mr. maybe clarified, we will rectify whatever the-
You are always permitted, if you, ಅವರು ಹೇಳ್ತಾರೆ ನೀವು ಕೊಡಿ ಅಂತ, ನೀವು ಕೊಡಿ. Interim order earlier granted is extended next year. You have to make a submission as to whether the land of the petitioner has been used or not. Adukonu, it takes such a long time. And be adjourning matters like this because each time the matter is listed, there are 15 people working on this. You start imposing cost and simple submissions cannot be made. Senior grade. Career in senior. This is not fair. Simple submission whether the land is used or not. Adumadakunu, you want time on that. So many people work on listing this file. Please understand. You chamber in the office ಬರ್ತಿರಲ್ಲ ಹಂಗೆ ಈ ಫೈಲ್ ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಬರಬೇಕು. Please get the counsel for respond number 4 once again seeks 3 and 4 deleted. Respond number 3 once again seeks 4 and is granted. A week's time to obtain instruction, make a submission. If submissions are not made by next date, orders would have to be, the submission of the petition will be considered and orders passed. Released on 8th September. This is important.
I filed it yesterday, I want to check.
We know the matter is listed today.
The difficulty was, my lord, this is the person whose name featured in the property taxes. I was unaware of his details, my lord, until I received the legal notice from me. And that came on.
Because of the matter was last listed on
14th,
14th.
my lord.
You know it is listed today.
Please, my lord.
2 days. It requires to be filed in advance for the application to be put up.
Please, my lord, as I said, my lord, this date.
That is why we have instructed, even if it comes later, put it up.
No, my lord, the difficulty was I did not have the details of this individual. I had only the name which was featured on the property tax listing. Then I received the legal notice from it, that's when I received.
The issue notice on IA 1 of 23 on the person named therein, returnable by 4th October.
Okay,
Just file it 2 days before the date on which the matter is listed, that's all.
absolutely.
In memo of a withdrawal is a
Stay.
no.
By issuing a termination letter to the earlier maintenance of state 2022 itself. So though the stay was granted, the petitioner in second petition, they are continuing silent for a period of 11 months. So after finishing of 11 months, they have issued notices for termination as well as to vacate. So on that, also he has not this year without the work order
given to the petitioner in the second matter.
Hmm.
So therefore, both, so we have taken our person and added our petitioner with the earlier petition. So now both the cases have become infructuous. So therefore, the petition.
One has to be dismissed as withdrawn, one has to be dismissed as infructuous. And
Our memo after the second matter.
when the withdrawal is.
Yes.
What about the first one? Mr. Reddy is saying, even the first one is infructuous. I heard I agree, Mr. Reddy. First one is submitting is infructuous.
With your lordship's kind indulgence, my lord.
I can particular.
11.1 ನಲ್ಲಿ ಯಾರು? ನೀವು 11 ನಲ್ಲಿ ಯಾರು?
My lord, I appear in 11, my lord. Mallikarjun Reddy, my lord.
Mr. Reddy, you are appearing for response. Who appears for the petitioner? ಆಯ್ತು. First petitioner ಯಾರು? petitioner ಯಾರು? Where is Mr. Vijay Shetty? ನೀವು ಈ ಕಡೆ ಬನ್ನಿ. ಈ ಕಡೆ. Okay, ನೀವು ಮಧ್ಯದಲ್ಲಿ. So ಇವಾಗ infructuous ಅಂತ ಇದ್ದಾರೆ. What is your submission? Restore ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇದ್ದಾರೆ ಅವರು. When did you restore, Mr. Reddy? ಯಾವತ್ತು ರಿಸ್ಟೋರ್ ಮಾಡಿದ್ರು ಅವ್ರಿಗೆ ಪೊಸಿಷನ್? One eight. ಇವತ್ತು 19. ಅದಕ್ಕೆ ಅವ್ರು ರಿಸ್ಟೋರ್ ಮಾಡಿದ್ದಾರೆ. ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ದೀರಾ? But do you have any information about it or no? We'll pass over the matter, get information.
My lord.
It will restored, it will be restored.
With your lordship's kind indulgence, my lord, I don't have an entire set of the petition as well as the annexures, my lord. In serial number 11, my lord.
We'll direct them to furnish it to you, but if what Mr. Venkat Reddy is saying that the possession has been given to the petitioner in the first matter, the first petition also becomes infructuous. So let him get instructions by afternoon, we'll take it up.
Please, my lord.
ನೀವು ಇಲ್ಲ ಅಂದ್ರೇನು ಪರವಾಗಿಲ್ಲ. Yes.
After declared statement of objections, the matter went back and offered by the society. Government has the same plan. And the handing over person to me. After the handing over the person to the handing person, the Tata has been in the that question.
Who appears for the BDA? Yes, Mr. Krishna, you have to comply with para 8 of the order dated.
This property is included.
Is included and sites have been formed. So that we can. ಒಬ್ಬೊಬ್ರೆ ಹೇಳಿ. So according to you, this property is included in the layout formed by which society? Is not a party to these proceedings. They not made them a party.
They sold it to my vendors after forming the sites. It is not bad. That is not bad.
So according to you, it is part of it. Yes, madam.
They are being saying that the property has given back to the original. Way back in the year, the resident of, if you want that land, they have to follow the procedures, they have to acquire it. As per the Supreme Court direction.
Both your statements are contradictory. The BDA is saying they have sanctioned a plan. You are saying it has been denotified. How can both happen?
The name of the person.
After the plan sanction.
Meeting that it was earlier given also, but it was challenged, subsequently it was re-notified by the government. The re-notification was challenged by the landowner. And so that is the entire, a lot of the Supreme Court matter, they got the re-notification applied. Thereafter, when they never found that is reading us, our their plan also is property included as well as plan of tax.
And I'm glad that both are not properly in the facts. Both are not. In my statement.
ಎರಡು ಸ್ಟೋರಿ ಆಯ್ತು, ಮೂರನೇ ಸ್ಟೋರಿ ಹೇಳಿ.
In my
ಅವ್ರು
statement.
ನಾಲ್ಕನೇದು ಹೇಳ್ತಾರೆ.
In my statement of objection, many
Let all these, whatever you want to say, please place it on record in writing.
I think that of denotification has no direction from the effects for the society and the PDA and the government was directed to hand over to the actual owners. And to pay back award amount whatever they have received. And the authorities have initiated to pay back in the 9 hours. They have conducted another and they have handed over the person and the amount whatever is 5 lakh and that to the owner. It has been returned in the deed. Everything has been returned, the proceedings have been conducted both to the government and the land acquisition officer and we. These are the documents are filed along with the state number. That will totally open the entire issue. I can also furnish a copy to the council and to the PD and also the government. And furnish.
Please furnish it to him so that they can find. ಅವ್ರ ಆಫೀಸಲ್ಲಿ ಆಗಿಲ್ಲ, ಇದು ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆಗಿರೋದು. So you furnish those details. Whatever they'll file, they'll learn it. Shri K. Krishna, learned counsel for respond number 7. Learned AGA appearing for respond number 6. Seek for and are granted 2 weeks' time to file their objections on record. The said objections to be filed on or before 21st after serving a copy thereof on the other councils. Ms. Chaitravati BS has entered appearance for respond number 1 to 3. Register direct delete the name of Shri Pawan Kumar as that appearance for respond number 1 to 3. I will let Parag. Then Shupraka, you are appearing for?
That's for 4 months.
5.
4 the same time branch.
Wakalatnama. Registry has raised an objection on the Wakalatnama filed by respond number 5 that no objection has not been obtained from the council who has filed the caveat for respond number 5, 4 and 5. Council for respond number. Council for respond number 4 submits that he has no objection for Shri Vivek Holla to appear for respond number 5. Hence, office objection does not survive for consideration. The Wakalatnama is taken on record. Released on 27th.
Right now.
Ella copies ಕೊಡ್ಲಿ. Interim order earlier granted is extended till next. Mr. Sachin? Lukwa? Shumaga Bajrao. The AG accepts notice for respond number 1. The AV Gangagrappa for respond number 2. Same order. Last week. You will have to send the order to them by registered post. 13 and 14 same order. Buy 1, take 1 free. Buy 2, take 3 free. 20? 23, 24, 25. Same orders. Please inform Mr. Gangadharappa.
I have informed it.
15, my lord, serial number.
Yes, Mr. Sridhar.
My lord, they have to submit report. I will collect it and then next week it may become. They have not submitted report.
Phone number 5, Mr. Karthikeyan.
My lord, let me also collect the copy. Next
Yes.
week it may.
We are seeing it as to what is there. It will be given
Yes.
to you.
Yes.
They appear to have removed it. You have a look at it. Yes,
I'll submit. Next week it.
As filed. 2 memos. The first memo. I have 2 memos along with documents. Said memos are taken on record. Copies are directed to be furnished to the counsel for the petitioner. Respond number 6 and 7 acknowledges receipt of the copies. Released on 8 September.
Much obliged.
This is non-filing of amendment application. 19.4, yes.
Division is imposed. With regard to the portion of land which is being now incorporated in the master plan, it shows that there is being one road. Therefore, there was a condition imposed in the sanction plan, in the application which was submitted to relinquish that portion.
Yes.
Last occasion was part because we showed that the zonal regulations under the master plan, as we have as directed us to incorporate the condition. Very interested, they will challenge the condition itself by law, master plan. And then they will file an amendment application.
Which authority are you appealing to?
Page 32 not order.
You are not challenging that trigger.
That may not be necessary.
See, there are 2 aspects in that because most of them have just copied it. One is it's giving a TDR. They are not giving the compensation in terms of money, but they are giving TDR. If you are acceptable for the TDR, you can go in for the
So they
TDR.
are not offering TDA. They are not offering.
Your authority is not offering. Where is that regulation?
But sir, page 33 not is the include condition, condition number 2. My lord, sir. ಪ್ರಶ್ನಿತ ವಿನ್ಯಾಸದಲ್ಲಿ ರಸ್ತೆಗಾಗಿ ಕಾಯ್ದಿರಿಸುವ ಸುವರ್ಣ ಚದರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣ ಜಾಗವನ್ನು ನೋಂದಾಯಿತ ಪರಿತ್ಯಾಗನ ಪತ್ರದ ಮೂಲಕ ಪುಕ್ಕಟ್ಟೆಯಾಗಿ ಸ್ವಚ್ಛಾಗ್ಯ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಹೊಂಬಂಡೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಇವರಿಗೆ
They are saying that they are imposes in terms of a regulation. Which empowers. What do you have regulation? BIAPA, BMRDA have that regulation. Is this also the same? Which is the regulation number?
8.2B pertains to non-residential area.
Yeah. For four.
Hmm.
In cases after the incorporation of the road proposed in the master plan, the area of road shall be handed over to the local.
15.2B.
Two, I'm sorry, two, yeah, two, yeah.
15.2A.
Two, yeah.
Yes.
Number four. In cases after the incorporation of road proposed in the master plan, the area of roads shall be handed over to the local authority free of cost to the resident. Because of this clause, we had imposed this.
Where's your plan?
That is not page 34.
Plan.
Plan.
Plan is 35.
The sketch plot is at page 34.
So this is a single plot.
It's a single plot. And not single plot. Will kindly see, I have not demarcated any road.
Single plot, this won't apply. Single plot, this won't apply.
This was.
How can it be for single plot?
That's what the municipal says, but hence I. Okay, point to give access. If the private non-residential layout. Of only one single. One single unit.
We challenge this.
But they just take my lords, but I don't have the need to challenge this for this reason. They just take my lords to the plan here. For a moment.
You are running the risk. You are running the risk.
But
You want to run the risk, it's your choice.
but I just read out this very regulation.
After that, don't say you want time. We'll, this way or that way, we'll dispose the matter.
But for a moment.
Don't ask for time afterwards.
No, I won't see. But I'll read that regulation once again if I learn. In cases after the incorporation of the road proposed in master plan, the area of roads shall be handed over to the local authority free of cost to a registered delegation. Now, whatever has been, if at all any plan, that depicts a portion as a road, and if that portion perhaps has been included in the master plan, perhaps I'm bound by this. But here is a case perhaps where the property abuts a national highway. But the national highway and the service road is not part of their master plan.
It is not incorporated in the
It is
master.
not incorporated.
Where is the master plan?
But sir, the master plan, of course, they have to place that on record. Not even as per the NOC granted by the NHAI, the portion which they are now asking for relinquishment is part of the road marks. But I take my lord's.
Is this area that they are asking for part of the master plan or no?
It is not. My respectful submission is it is not because it is part of the national highway.
Then he is right that it doesn't meet the challenge. If it's part of national highway and not part of the master plan, you can't even impose this.
It was part of the national plan. Road required for the it would automatically be a road. This is a portion of private land which was.
Mr. Ajay, if you have made a plan in terms of section 13 and 14 of the KGCPA, now called master plan or development plan or revised master plan, in that you have to apply your mind and earmark or demarcate a particular area for formation of a new road or widening of an existing road. You have to apply your mind to that. So if that is there in the master plan, yes. You cannot rely on what National Highway Authority of India is doing to incorporate it. National Highway Authority wants to do something, they'll acquire it. It's not for you. So is this widening that you are asking for part of the master plan? Then please produce the master plan.
But for a moment.
Until we see the master plan, how can we do it?
Like
National Highway, you go different. Plan, either you have to place or if that is your condition, you should have placed it. Website alilwa.
More meters in data. One more. Just placing this for not consideration. I will consider. Only if I depict that portion as a road.
No. That you may be wrong.
Very well.
If it is shown in the master plan, you cannot develop anything there.
Very well.
If they want to acquire, they'll have to pay compensation, but
Yes.
they won't grant you a sanction in that area. After you build there, then they'll have to demolish it again. There's no point.
even otherwise, but I have made a statement that not a brief will be placed on this.
If it is, Mr. Shetty, please understand. If it is not part of the master plan, you don't need to challenge it. If it is part of the master plan,
Yes.
you will have to challenge 15A. Without challenging, your relief is not maintainable.
Very good. Very good.
So the choice is left to both of you. You will have to place the master plan. After arguing for some time, Shri Ajay Kumar, Learned Counsel for respond number 361 is granted weeks time to place the master plan, subject matter of the above petition relating to the petitioner's property, indicating that in the master plan, there is a proposal to widen the existing road. Released on 8th September.
17, that is good.
That you wanted to F. Okay. The name of the father and mother was left out.
Annexure A, the registration has taken shape. There's the page birth.
Yes.
Father and mother name is there.
Yeah.
But not the name to date of birth is also there.
What are the other supporting documents you have produced?
Access to mother is the Aadhaar card. Annexure B, mother, C1, page 17. Passport. And annexure B to mother. Birth certificate. E3 is migration. Other than this, all master.
What more do you want?
Well, considering that will us out of the
Then you will have to do one thing. You will have to find out from your records where the baby's name has not been inserted. Give notice to each one of them and ask them to come and enter the name. We're not able to understand why this kind of a rule. We are not in the West. In America or Europe, the baby is named at the time of the birth and the baby's name is entered in the certificate. Normally, Namkarana Agadu will be 3 months later. After a lot of discussion, lot of fights as to what the name has to be. So name of the baby will never be known at the time of birth. Firstly, there's no sex determination. Therefore, you don't even know whether it's a boy or a girl. Only there. So they are ready that it's a boy or girl with a name. Illilla. You cannot expect them to enter the name of the baby at the time of the birth or immediately thereafter.
Now, you are just.
They're put on notice. You change it now. What about this girl is aged how much? This girl was born in 2000. 2000 I'll do it. If you want, you have to enable things. More we are saying BBMP, instead of enabling things, is always obstructing things. Enable what? You're there to serve the interest. Father and mother have come giving you all these documents, you don't want to enter it. Petitioner is before this court, seeking for the following leaves. The petitioner is a citizen of India and at present pursuing a master's in management program at IE University, Madrid, Spain. The petitioner was born on 28/4/2000 at Bhagwan Mahavir Jain Hospital. And in the birth certificate which had been issued, the name of the father and mother of the petitioner was incorporated. However, the name of the petitioner was not mentioned in the said birth certificate. Subsequently, the petitioner has carried on all her education in Bangalore, in Cochin. She has studied until her 10th standard at Vidyodaya School, Cochin. The petitioner had applied for and issued Aadhaar card, passport, as also on completing her education, she was issued the grade sheet cum certificate of performance by the Central Board of Secondary Education. On a requirement having been arisen for her to place the birth certificate on record. Why did you want it? For employment purpose. The petitioner made an application to the respondent for inserting her name in the birth certificate. The said request came to be rejected by the respondents via Annexure E, dated 7/3/2022, on the ground that, as per the instructions issued by the Ministry of Home Affairs, a 15-year period had been prescribed under had been provided for entering the name of the person born in the birth certificate, if not already entered into. And the said 15-year period, having expired in the year 2015, was extended for a period of 5 years thereafter, which also expired in the year 2020. And subsequent thereto, there is no provision to incorporate the name of the person born in the birth certificate, since the period has expired. It is agreed by the same that the petitioner is before this court, seeking for the aforesaid. Learned counsel for the petitioner would submit that all and every record of the petitioner, apart from the birth certificate, indicate the name of her parents. There is no dispute as regards the petitioner being born to Shafi Mathur and Beena Mathur. It is only that her name had not been incorporated in the birth certificate on 28/4/2000 when it was issued. the said fact being of no consequence since all other documents had been issued to her. It is only when a requirement arose that an application was filed, which has been refused, which ought not to have been refused. So there is only a clerical work to be made of insertion of the name of the petitioner in the birth certificate. On this ground, we submit that the above petition is required to be allowed and the relief sought for to be granted. Shri Pawan Kumar, learned counsel appearing for the Respondent Corporation, however, submit that it is only on account of the instruction issued by the Ministry of Home Affairs that the insertion could not be made since the period has expired. And on that ground, he submits that the hands of the respondents are tied and no fault could be found with the respondents. Third, Shri Rakesh B. Bhatt, learned counsel for the petitioner, Shri Pawan Kumar, learned counsel for respondent number 1, introduced to us. The only reason why the short point that would arise for consideration is whether the municipal corporation who is in charge of issuing births and death certificates in terms of the Karnataka Registration of Births and Deaths Rules 1999 can seek to refuse insertion of the name of the person born in the birth certificate when such an application is made. The only ground on which the application made by the petitioner has been refused is allegedly on account of delay and or latches, in as much as the said application has been made beyond a period of 20 years from the date when the rules came into force, that is in the year 1999. Apart therefrom, there is no other reason made out by the respondent itself for such refusal. It is not in dispute that the petitioner is born to Mr. Shafi Mathur and Mrs. Beena Mathur on 28/4/2000 in the Bhagwan Mahavir Jain Hospital, and a birth certificate to that effect has been issued. In the said birth certificate, the name of the petitioner, name of the baby, that is the petitioner, has not been mentioned. The petitioner has produced her Aadhaar card, which has been issued by the Unique Identification Authority of India, wherein the name of her father, Mr. Shafi Mathur, has been mentioned along with the address. A passport issued by the passport office has also been produced, which indicates the name of both the father and the mother with the address. Certificate issued by Central Board of Secondary Education has been produced, which indicates the name of both the father and mother. These documents accompanied the application filed by the petitioner for insertion of the name of the petitioner in the birth certificate. The birth and death rules. Yes. In terms of Rule 10 of the Karnataka Registration of Births and Deaths Rules 1999, an application for registration where a birth of any child has been registered without a name, the parent or guardian of such child shall within 12 months from the date of registration birth of the child give information regarding name of the child to the registrar, either orally or in writing. Thus, the proviso to Rule 10, subsection 1 of Rule 10, sub-rule 1 of Rule 10, there is a period of 15 years which is to be taken in terms of the proviso to sub-rule 1 of Rule 10. The information given after the aforesaid period of 12 months, but within the period of 15 years, could be taken into consideration for purpose of such entry. It is on that basis that the respondent corporation has denied registration, contending that there is a further extension of a period of 5 years after the expiry of 15 years. The birth certificate which has been issued and produced at Annexure A does not indicate any requirement on part of the parent to comply with Rule 10 and/or the proviso thereof. It is therefore required that the requirement of Section 10 Rule 10 be incorporated in the birth certificate so issued if the name of the person born is not incorporated in the said birth certificate. In the absence of such a obligation being incorporated in the birth certificate issue, I am of the considered opinion that it would be difficult to now deny the petitioner the insertion of her name in the birth certificate merely because there's been a delay in furnishing the said details. The communication of the Ministry of Home is an internal communication between the Ministry of Home and the corporation authorities, and not one which is made known to the petitioner. In fact, the Ministry of Home has also categorically indicated that it will be the duty and responsibility of the corporation to make known the requirement of Rule 10 to everyone and give wide publicity thereof. One basic way of making known the same would have been to incorporate the said requirement in the birth certificate issued without a name. In that view of the matter, I am of the considered opinion that when the identity of the petitioner is not in dispute, the paternity is not in dispute, the petitioner cannot be denied a birth certificate with her name on it when several other documents have been issued to the petitioner with the name of her parents. In that view of the matter, I pass the following order. The writ petition is allowed. A certiorari is issued. The endorsement bearing number so and so dated 28/7/2023 at Annexure E is hereby quashed. A mandamus is issued directing the respondent to issue a birth certificate with the name of the petitioner included in the same. All other details as contained under Annexure A will remain unchanged. Respondent is also directed to incorporate the requirements of Rule 10 of the Karnataka so and so in all birth certificates issued henceforth. Within a period of job ಹೋಗ್ಬಿಡೋದಲ್ಲ. Within a period of 30 days from the date of receipt. Pending I does not survive the consummation. We have given different, that has a different fact situation. That's why this is a different fact situation.
Figure number 8. SC letter.
A sort of washing of the plants and for what reason?
But the reason is that I am also aware of the board. And there was a 2 acre for 78 acres of total extent land. And there was a partition in 1982. And there was 4 blocks, but that we told was that way the answer. But that was amalgamated without my consent. And they refused the plan. I think that the partition is also right. That's the 3 months. Reduced to 10 feet. 20 feet on the road was amalgamated with the adjacent property. That is the reason for that. One of the figures is the family,
If Pawan Kumar accepts notice for respond number 1 and 2, issue notice to respond number 3 to 15, returnable by 4th October. Same respondent, sir. Same one. Connect with each other. ಯಾವ್ದಪ್ಪ 152 1 ಹಂಗೆ ಹೇಳ್ಬೇಕು ಕವರ್ಡ್ ಅಂತ ಹೇಳಿದ್ರೆ ಪವನ್ ಕುಮಾರ್ accepts notice for respond number 4 and 5 learned AGA accepts notice for respond number 1 to 3. The petitioner is before this court seeking for the following reliefs. The list in the above matter has already been decided by this court by its order date 17th April 2023 in WP number 12954 of 2021. Hence, I pass the following order. Deposit in a Ridya.
Here was 21, 22, 22, 30. Has already been paid by the petitioner. I have sought for refund. But it may be adjusted in future.
Para 6 ಅಲ್ಲಿ ಇದೆ ಅದು already.
Please, interim order ಮೇಲೆ ಮಾಡಿದ್ರೆ ಅಂತ ಇದೆ. I have voluntarily deposited.
Para 6. The amount, if any, deposited by the petitioner is directed to be adjusted towards future tax payments due by the petitioner on the affected
Also,
property.
it is that circle.
Para 6.
Kumar.
Similar to
GST.
advertisement.
Yes.
Where the demand?
The demand is actually page 32. 30.
There are further demands in this, Mr. Shivakumar. ನೆಲಬಾಡಿಗೆ ಇದೆ, ಜಾಹೀರಾತು ಶುಲ್ಕ ಇದೆ.
Those payments that you made.
Which payments have you
Made.
made? Column?
Without that, I cannot carry on. Kindly see the documents which are.
There are matters coming up before us where it is being carried on without payment. In one of them, we refused. In your matter, it was only GST, we stayed that.
Only GST, but I only asked for And insofar as other things are concerned, we have paid,
So only column 5.
yes, all fine. But payment insofar as ground rent is concerned, we have paid in regard to all these. Without
So-
that, I cannot.
So you paid ground rent and GST for column 5
Yes.
and column 6. So we are only concerned with column 8 and 9.
Yes, all paid. Yes, are posted on the other.
The Learned AG accepts notice for respond number 1. The Pawan Kumar accepts notice for respond number. If BL Sanjeev accepts notice for respond number 3 to 5. The demand notices at annexure A and B, insofar as the demand made in column number 8 and 9, respectively in the said demand notices, are stayed till the next date of hearing. Connect the above matter with WP so and so, relist on 11th. Munyappa?
Any sanction or relation, they are constructing the buildings and they are at the foundation in a road which is between my property and their property. I have given representation to the authority, no action has been taken.
ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಏನಾದ್ರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆಯಾ?
Some property may have. The 26 by lot, the road, after the compound, there is the road in between both properties, they are laying foundation.
And AG accepts notice for respond number 1 to 3. Gundalpet terrace. Chandrakant Golde accepts notice for respond number 4 and 5. Issue emergent notice to respond number 6 to 10. Written up by 4th October 2023. The 4th and 5th respondent are directed to inspect the properties covered under survey number 142 and 143. Of Bhimanabeedu village, Kasba Obli, Gundalpet Taluk, Chamarajnagar.
They are constructing at 144 and 144, 142 and 143 belongs to me.
142 and 143 ಅಂತ ಹೇಳಿದಿರಲ್ಲ ನೀವು.
The representation will have 144 and
ನಿಮ್ಮ interim prayer ನೋಡಿ. And your para 2 also.
That is my land. 142 or 143 is the land of city. 144 or 145, they are land of the respondent. I will make the.
Then you have to correct your petition.
I will correct.
ಎಲ್ಲ ಕಡೆ ಮಿಸ್ಟೇಕ್ ಇದೆ.
Only in the immediate way.
ಅವ್ರ ಲ್ಯಾಂಡ್ ನಿಮ್ದು ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ ನಿಮ್ ಲ್ಯಾಂಡ್ ಅವ್ರದ್ದು ಹೇಳ್ಬಿಟ್ಟಿದೆ.
Be my land, where be my land. Further construction bearing survey number 144.
Para 2, para 3
To my land of the bay.
of your petition. Mr. Ramananda.
Belongs to me.
Para 9. ಎಲ್ಲ ಕಡೆ 142, 143 ಹೇಳಿದ್ದೀರಾ.
Belongs to be my.
Para 19 ಹಂಗೆ ಹೇಳಿ. ಎಲ್ಲ ಕಡೆ you have to change it. Change ಮಾಡಿ. After arguing for some time, learn counsel for the petition seeks for and is granted. A week's time to file amendment application to correct the reference to the properties in the petition, the prayer and schedule. Relist on 8th September. $150. ನೀವ್ ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ? ಹಾ, ಅದಕ್ಕೆ ನೀವೇ ಕೇಳ್ತಾ ಇದ್ದೀರಾ, ಅಲ್ಲಿಂದ ಏನು ಕೇಳ್ತಾ ಇದ್ದೀರಾ? Any amounts in deposit? And AG accepts notice for respond number 1, Pawan Kumar for respond number 2 and 3. Petitioner is before this court seeking for the following reliefs. The list in the above matter is decided and so on. 152. And no amount in deposit. Para 6. No para 6. Mr. Ebar. $27. That is what has been called out, Mr. Ram. Mr. Ebar was keeping you very busy. Too many instructions, Mr. Ebar. Yes, what is it, Mr. 2018 matter. You again, sir. What do you want to file your objections to? Respond number 5 and 6 have not filed statement of objections. What about the state? Mr. Naik is filed. So you want to file or you don't want to file? ಇಲ್ಲ registry ಅಲ್ಲಿ sir some copies of citation ಎಲ್ಲ ಇಲ್ಲ sir ಕೊಟ್ಬಿಡಿ advance ಎಲ್ಲ ಕೊಡಬೇಕು so that you can read and we don't need to adjourn it at that time. That is what point number 2 in our list is, but a lot of people don't follow it. Learned AGA appearing for respond number 1 and 2 and Shri S. Rajshekhar, learned counsels for 5 and 6, respond 5 and 6. Seek for and are granted 2 weeks time, 2 weeks time finally to file their respective statement of objection. The objections is to be filed on or before 21st September 2023. If the same is not filed by then, it will be taken as not filed and the matter proceeded. Relist on when do you want to start? 26, 27? Our Murvara ಬೇಕಂತ 21 ಅವ್ರು ಫೈಲ್ ಮಾಡ್ತಾರೆ 26, 27, 29 ಯಾವ್ದು 26 September by 21st after serving the same on the counsel for the petition. If you want to rely on any other judgments, anything, serve it before.
In this case, I'm appearing for the petitioners, my lords.
Yes. Who appears for the respondent?
Jagdish Charya.
Bandrala. Yes. Who appears for the Nagashri?
Corporation, my lords.
You are the contesting parties.
Yes, my lords.
Yes, madam. Yes, please.
The petitioner filed by the petition is claiming that the property bearing number 75/4 and 75/5 in Khata number 151, 152, 153, my lords, in Bowie Colony, Bomanhalli, was in accordance of the partition deed dated 24/4, 1976, which is an unregistered partnership deed, my lords. And on the basis of the partnership deed, my lords, the Gram Panchayat had effected the khata in the name of the
Partition or partnership?
partition deed.
Partition. Yes.
Partition deed, my lords.
Yes.
The khata was effected in the name of the petitioners, that is her husband, my lord, in the year 1978-79. The
Yes.
measurements were recorded and accordingly the according to the partition deed, the revenue tax has been paid in respect of the property which belongs to the petitioners, my lords. My lords, the jurisdiction of this property got transferred from Gram Panchayat to Nagara Sabha Bamunhalli. During this transition period, my lords, the measurements of the property in the khata 152-153 was tampered, my lords. If my lordship could turn to page 47, my lords.
Yes.
My lords, 152, my lords. Over here, it clearly shows that the measurements have been tampered. The original measurement, my lords, if it can be seen, that is 52 into 58, my lords. Besides it, it has been written as 120 into 62. At 153 khata number, my lords, my original measurement, it is clear, my lords, 30 by 35. Now it is indicating as 5 into 3, or my lords, 5 into 6. See that measurements have been tampered, my lords. The original measurement was 30 into 35. Now it has been tampered and shown as 5 into 6. And in 152, the original measurement was 52 into 28, has been shown as 12 into 20.
Yes.
It is very clear, my lords. They responded the written statements, and the petition had filed several documents, my lord, including the partition deed also, before the first respondent.
Where is the partition deed?
Partition deed is at Annexure C, my lords.
Page?
24-25, my lord. 17, my lords, and it has been retyped at page number 22, 23, 24, and translated into 24, my lord, 25, my lords, at page number 25.
What is the measurement in this?
They have not stated the measurement, my lords. Yeah, it is there, my lords, here. Because there were 3 sons, my lords, of Mr. Annayappa, that is Annayappa, the first son, second son being Shamanna, and the third son being Ramu. Ramu is the husband of the petitioner before this honorable court.
So what came to Mr. Ramu's share?
Ramu's share is this, my lords.
Where is it shown?
Where is it shown? Schedule C, my lords. It has been stated belongs to Ramu. It's Schedule C, my lords. What is that? I have produced one sketch, my lords. sketch at 46, my lords.
No, show us from the document as to where is Mr. Ramu's name? And what is being given to him?
My lords, here, my lords, this annexure C, my lords, in this it declares that the property which is in possession of the three sons shall be measured and accordingly transferred into the name of the three sons. My lords, according to the annexure, that is the sketch which I have produced at 46, my lords, it clearly indicates that I am in possession of Khata number 153, 152.
Survey number 75/1 came to the share of Ramu.
Yes. Yes, my lords. 74.
Kali Baga Mehta. Yes. Where is the sketch? But there's no measurement.
Measurement is there.
Where is the sketch?
At 46, my lords.
46. Yes.
As per the sketch, my lords, Khata number 151, 152, and 153 belongs to Ramu. And on the right hand side, my lords, house belongs to Anayappa. That is the respondent number 2, my lords, 225. And here Shamanna. On the above, that is above 152 is the property which is belonging to Shamanna. That is the second son of Anayappa.
Yes.
My lords, while passing the order, impugned order, the first respondent has stated that the records has stated, yes, the record, it has been noticed that the records has been tampered. The measurement has been tampered in property 70/4. And the partition property was registered in document number the document number 7035/5758. That is this property which was registered and purchased in the year 1958, my lords. And the court further directed that to the assistant surveyor to survey the land and divide equally among the parties to this petition. That is the petitioner and the respondent 2 and 5. He has exceeded his jurisdiction by ordering for division, my lords.
Overriding the partition deed is.
Yes, my lords. Yes, my lords. So my humble prayer before this honorable court is to quash the impugned order and to restore to its original.
Survey is fine. Survey to be in terms of the partition deed, not in terms of division in 3 portions.
Yes, my lords. Yes.
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 Connection. As per the petition of application, this order of the corporation. You understand? Particular service, आपकी संख्या 45 खाता नंबर 151 ಗೋಪಿ ಕಾಲನಿ ಬೊಮ್ಮನಹಳ್ಳಿ ಆಸ್ತಿ ತಮ್ಮದಿಂದು ಹಾಗೂ ಆಸ್ತಿ ವಿಭಾಗದ ದಿನಾಂಕ 24/4/2023 ಈ ವಿಭಾಗದ ಆಧಾರದ ಮೇಲೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ನಲ್ಲಿ 78 ಎಂದು ನಮೂದಾಗಿರುತ್ತದೆ ಎಂದು ತಿಳಿದು ಸದರಿ ಆಸ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಂದಾಯ ಪಾವತಿಸಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಿಂದ ಬ್ರಹ್ಮನಾರೆಡ್ಡಿ ನಗರಸಭೆ ಉದ್ಘಾಟನದ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ದಾಖಲೆಗಳನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿದ್ದಾಗಿಯೂ ಸದರಿ ತಿದ್ದುಪಡಿಗೆ ಸಂಬಂಧಿಸಿದ ಲೀಗಲ್ ನೋಟಿಸ್ ಅನ್ನು ದಿನಾಂಕ 19/2/2007 ಪಡೆಯಲಾಗಿದೆ ಎಂದು ತಿಳಿಸುತ್ತಾ ಮೊದಲನೇ ಪ್ರತಿವಾದವು ಸದರಿ ದಾಖಲೆ ತಿದ್ದುಪಡಿ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ತಿದ್ದುಪಡಿಗಳು ಸರಿಪಡಿಸಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ದಾಖಲೆಗಳ ಅಳತೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಸ್ತುತ ದಾಖಲೆಯನ್ನು ಸರಿಪಡಿಸಿ ನೀಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ವಿಭಾಗ ಪತ್ರ ನಗರಸಭೆಗಳು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಪ್ರತಿವಾದ ತಮ್ಮ ಲಿಖಿತವಾದವನ್ನು ಮಂಡಿಸುತ್ತಾ ಪಂಚಾಯತಿ ದಾಖಲೆಗಳಲ್ಲಿ ಪಂಚಾಯತಿ ಕಾರ್ಯದರ್ಶಿಗಳನ್ನು ಸೇರಿಸಿಕೊಂಡು ಸ್ವಯಂ ಸೃಷ್ಟಿಕೃತ ದಾಖಲೆಗಳನ್ನು ಮಾಡಲಾಗಿದೆ. ಹಾಗೂ ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಚಯಿತಾರರು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಹೂಡಿದ್ದು ದಾವೆಯಲ್ಲಿ ತಮ್ಮ ಲಿಖಿತ ಹೇಳಿಕೆ ಅರ್ಜಿದಾರರು ತಿಳಿಸುತ್ತಾ ವಿಭಾಗ ಪತ್ರದ ದಿನಾಂಕ 25/4/2023 ವಿಭಾಗ ಪತ್ರವು ಸೃಷ್ಟಿ ಕೃತ್ಯವ ದಾಖಲಿಸುತ್ತಾರೆ ಎಂದು ಅರ್ಜಿದಾರರೇ ತಿಳಿದಿದ್ದು ಪ್ರಸ್ತುತ ಸದರಿಸುವುದು ವಿಭಾಗ ಪತ್ರದ ಮೂಲಕ ಬಂದಿರುತ್ತದೆ. ಅದರಲ್ಲಿ ಬಿಬಿಎಂಪಿ ಕಾಪಿ ಮಾಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಸುತ್ತಾರೆ. ಮುಂದುವರೆದು ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ವಿಭಾಗ ಪತ್ರದಲ್ಲಿ ವಿಭಾಗಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ಅಡೆತಡೆಗಳನ್ನು ನಮೂದಾಗಿರುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸುತ್ತಾ ವಿಭಾಗ ಪತ್ರವನ್ನು ಮಾನ್ಯ ಮಾಡಬಾರದೆಂದು ಹಾಗೂ ಸದರಿ ವಿಭಾಗ ಪತ್ರ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಕ್ಟ್ ನೋಂದಣಿಯಾಗದೆ ಇರುವುದರಿಂದ ಇದಕ್ಕೆ ಯಾವುದೇ ತರಹದ ಮಾನ್ಯತೆ ಇರುವುದಿಲ್ಲವೆಂದು ಹಾಗೂ ವಿಭಾಗ ಪತ್ರದಲ್ಲಿ ರಚಿತರ ಸೊತ್ತಿಗೆ ಮಾಸ್ಟರ್ ಅಳತೆಯನ್ನು ನಮೂದಿಸುವುದು ಮತ್ತು ಉಳಿದ ವಿಭಾಗದಾರರ ಹೆಸರಿಗೆ ಅಳತೆ ನಮೂನಾಗದೇ ಇರುವುದು ಹಾಗೂ ಹೆಚ್ಚಿನ ವಿಭಾಗ ಅರ್ಜಿದಾರ ಭಾಗಕ್ಕೆ ದಾಖಲಿಸಿರುವುದು ಗಮನಿಸುತ್ತದೆ. ಈ ವಿಭಾಗ ಪತ್ರವು ಸಮಂಜಸವಾಗಿ ವಿಭಾಗವಾಗಿಲ್ಲವೆಂದು ತಿಳಿಸುತ್ತಾ ಈ ವಿಭಾಗಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಅರ್ಜಿದಾರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ OS 2740/2000 ದಾವೆ ಸಲ್ಲಿಸಿತ್ತು. ಸ್ಥಿತಿ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯವು ಅದೇ ಪ್ರಕರಣವನ್ನು ಇತ್ಯರ್ಥಪಡಿಸುತ್ತಾ ಅರ್ಜಿದಾರರ ಅರ್ಜಿಯನ್ನು ಹಿಂಪಡೆಯಲು ಸೂಚಿಸುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿ ಸದರಿ ನ್ಯಾಯಾಲಯ ಆದೇಶ.
ಏನಾಯ್ತು? OS 240 ಏನಾಯ್ತು? 2740 ಏನಾಯ್ತು? OS 2740 ಏನಾಯ್ತು?
That has been withdrawn by the it's a different. It's right here. Here also I'm 195. It's been happened. That has been withdrawn. And also direction. ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದಗಳು ಸಲ್ಲಿಸಿ ಲಿಖಿತವಾದ ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದೆ ವಿಭಾಗ ಪತ್ರದಲ್ಲಿ ಎಲ್ಲಾ ವಿಭಾಗಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಸ್ತೀರ್ಣವನ್ನು ದಾಖಲಿಸದೇ ಇರುವುದರಿಂದ ಹಾಗೂ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಮತ್ತು ನಗರಸಭೆಯಲ್ಲಿ ನೀಡಿರುವ ಕಾಲವನ್ನು ತಿದ್ದುಪಡಿಯಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಹಿಂದೆ ಬೇಗೂರಲ್ಲಿ ಗಮನಹಳ್ಳಿ ಗ್ರಾಮದ ಕಾಳೇಶ್ ಕುಮಾರ್ ಎಂಬ 70/4 ಸ್ವತ್ತನ್ನು ದಿನಾಂಕ 20/2/58 ನೋಂದಣಿ ದಸ್ತಾವೇಜು ಬೆಂಗಳೂರು ತಾಲೂಕು ನೋಂದಣಿ ಕಚೇರಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ನ್ಯಾಯಾಲಯವು ಸಹ ಕಂದಾಯ ಅಧಿಕಾರಿ ಬೊಮ್ಮನಹಳ್ಳಿ ಉಪ ವಲಯ ನಿರ್ದೇಶನ ನೀಡುತ್ತಾ ಮೋಜಣಿದಾರ ಸಹಾಯವನ್ನು ಪಡೆದು ನೋಂದಣಿಯಾಗಿರುವ ಸ್ವತ್ತಿನಲ್ಲಿ ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿ ಅಳತೆ ಮಾಡಿ ಸುಮಾರು ಖಾತೆಯನ್ನು ದಾಖಲಿಸುತ್ತಾರೆ. ದಿನಾಂಕ 24/1/2015 ತೆರೆದ ನ್ಯಾಯಾಲಯ ಘೋಷಿಸಿದೆ. illegal order. As per instruction, as per application, you make this order pass by the respondent.
Here is the application. As per application was as per the partition deed. Partition ನಲ್ಲಿ ಸಮಭಾಗ ಇಲ್ಲ ಅಲ್ಲಿ. ಸಮಭಾಗ ಎಲ್ಲಿಂದ ಬಂತು?
ತಿದ್ದುಪಡಿ ಆಗಿದೆ.
So Jagdishwachar, can the which respondent? Can the first respondent order a partition? Samabhagadalli. When a partition deed says something else. Is it in his jurisdiction? He should have said, go to a civil court. He thinks that what has been allotted to each one is not. The same, therefore, Samabhaga Anta Madak Baratta. Who appears for the corporation? If Nageshri. This order is not proper. Cannot sustain. Corporation or another, or reaction thrown with Adhika or Bhatta. Who is the joint commissioner to decide Samabhaga? Full bench has categorically said you can't get into these things.
Case number 427.
We will set it aside and remind it for consideration of the application in terms of the partition deed. He cannot decide this like this.
My lords, in accordance with the partition deed, the survey was conducted and accordingly the measurements were incorporated.
In terms of the partition deed.
Yes, my lords.
Petitioner is before this court seeking for the following.
And I am in possession of the property since then, my lords, till
You
date.
cannot get into those things in a writ petition.
No, lords, I am in possession till now, my lords.
Petitioner had made an application for issuance of a CASA in terms of a partition deed entered into within the family members of the petitioner on 25/4/1976. Though there are several other allegations made as regards tampering with the documents or otherwise of the erstwhile Gram Panchayat, by way of the impugned order, the first respondent has come to a conclusion that the allotment of shares under the partition deed was not equal and or not equitable, and as such has directed the surveyor to carry a survey and allot equal portions to all the members of the family. And we consider opinion that they said the first respondent joint commissioner does not have any authority to have come to a conclusion that the allotment under the partition deed is not equal or equitable, nor does he have power or authority to direct equal partition of the properties. What the joint commission was to act in terms of the application filed in terms of the partition deed dated 25/4/1976 and to implement the said partition by issuing necessary CASA as per the property allocated under the said partition. In that view of the matter, I am of the considered opinion that the impugned order passed by the first respondent is not sustainable. And as such, I pass the following order. If it is allowed, a certiorari is issued. The order bearing number so and so, dated 24 January 2015 at Annexure A is hereby quashed. The first respondent, the matter is remitted to the first respondent to consider the application filed by the petitioner in terms of the partition deed dated 24/5/1976 and pass appropriate orders therein. While doing so, the petitioner, first respondent, shall keep in mind the directions issued by this court, by a full bench of this court in JM's case.
Much obliged, my lords.
Thereafter, the administrative officer of the Gram Panchayat should the modified plan as per annexure T page 19. 1/4/1994. After a lapse of more than 20 years, the respondent BBMP had issued the notice. I said page 19. Respondent BBMP has issued the notice on 10/3/2014.
Yes.
With regard to that, in the last petition from this court, that I think the learned to verify the notification because earlier this was all the properties are concerned under the Panchayat. April 2007, the 7 CMCs in around Bangalore and also about 100
Merged with the
villages,
BBMP.
100 villages have been comes under the jurisdiction of the BBMP in 2007.
Yes.
So with regard to that, in the previous occasion, this court has directed the learned to verify with regard to that notification.
ಏನಂತ verify
ಅದು notification ಯಾವಾಗ ಎಷ್ಟು 7 CMCs ಬಂದ್ಕೊಳ್ತಾರೆ ಅದರಲ್ಲಿ 100 villages also included in 7 CMC along with that they made it as a Surat Bangalore Mahanagara Palika.
order dated?
April 2007. That was the information that is issued.
2007.
Yes.
ಅಲ್ಲ 2007 ಆ ನೋಟ್ ಇಲ್ಲಿ ಆರ್ಡರ್ ಡೇಟೆಡ್ ಕೇಳ್ತಾರೆ.
That order before this question before this court is annexed act.
When did the direction, you said there's a direction issued by this court to the respondent. When was that direction issued?
Before last occasion, the Lord Chief Justice, Pandit Sahab will mind.
Date? 4/1/23. Get instruction as to when the area in question has come within the jurisdiction of BBMP and what was the bylaw applicable to the sanction plan in the year 94-95. 2007 bantu. But what is the bylaw applicable in 94-95? Then how can you issue this notice?
So after lapse of 20 years, in 2014, the salary issued.
They've enclosed the road.
80 or
Where is the 321 one?
page 24. So I have not included any road, but even this court can appoint the commissioner to verify that.
Where does it say he has enclosed the road in this?
I have not consulted anything that happened to
What
the
does it
side.
say? That's in Article 30 into 40. What is the property size of yours? Measurement of
30-40 million. That have purchased this property on 31/3/1995. Prior to that, the building was existence in the year 1963 itself. Then in 94, the property has been renovated. Then in the 95, I purchased this property.
You are trying to apply RMP. We'll measure your site. Whether it's 30-40 or more.
No, that is 30-40, that too large. The original building was in there 1963. The renovated plan was approved on 1994. This petitioner has purchased this property, renovated property in the year 1995. So the plan, BBMP has issued the notice on 10/3/2014.
Now the contention, the twofold contention. One is as regards violation of the building bylaws as per the RMP. That you are right in saying that the RMP bylaws will not apply. Of 2015 will not apply to a construction which you have carried out.
1963 and 94.
1963 hoito, 94.
94.
94. That you may be right, it's subject to the bylaws which are there of 94. The second contention, is of Mr. Pawan Kumar saying that you encroach upon the road. Your site measurement is 30-40. So we'll appoint a commissioner to see if it is 30, 40 or more. If it is more than 30, 40, you have encroached the road. In
In fact,
the meanwhile, we will produce the bylaws which are applicable in 90. ಎರಡು ಒಟ್ಟಿಗೆ ಮಾಡ್ತೀವಿ ಒಂದೊಂದು ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ ಇನ್ನು ಲೇಟ್ ಆಗುತ್ತೆ.
Well, also, granting the entry model, we see this court has granted entry model 18th June 2015 law.
Yes.
So at that time, this court has opined that because the petitioner has, with regard to the, not with regard to the encroachment of road, with regard to the other things, is applied for the scheme under Akrama Sakrama. The court has also observed that, and it's a big case for that regular Akrama Sakrama with regard to the other set, not with regard to that road.
That will come to once the bylaws are produced. Then whether the benefit of section 240 and 248 can be given. Two 240 subsection 8 of section 240 I think. Now 240 or 249 of the VPMP Act. It is in pari materia with 321A. 321A is there, but 249 stay agilwala. If 249 is not stayed, then benefit would be given. That was in a different context. Yesterday we have allowed one petition, 249 benefits. So who will carry out the measurement? Respond number? Aston Lake City engineer either. Second response. The issues in the present matter are twofold. Firstly, it is concerned by the BBMP that there is a encroachment of the road. And secondly, it is contended that there is a violation of the building bylaws as applicable to RMP 2015. The construction apparently having been carried out in the year 1994 in terms of the plan sanctioned in the year 1994. What would have to be considered is the building bylaws as applicable to the petitioner's property in the year 1994. Land Council for respond is that produced the same. Insofar as encroachment of the road is concerned, respond number 2 is directed to carry out a measurement and preparation and prepare a sketch of the property bearing number 6, old PID number 4-79-42, new PID number 035-W0069-10, situated at 42 Venkateshwara Extension, Mattikere, Bangalore. In as regards the measurement of the property on all sides, as also as regards the construction which has been put up on the property. Since the order is passed in the presence of the council for the petitioner, the inspection and measurement shall be carried out commencing from 10:30 AM on 11 September 2023, report to be filed by 15 September after serving a copy thereof on the council for the petitioner. Relist on 25th September. Earlier granted is extended with the photographs portfolio. We'll have to give us the 94 bylaws, what were applicable then.
Here are about 30 or 31.
Yes.
First, we will take page number 18, and shall see.
Hmm.
So there was a specific direction issue by the applicant president. Because at page number 24. Is the continuation of the
24.
relevant notes are page 24.
Yes.
But after considering what's several issues, but ultimately the eight boards was that ಮೇಯರ್ ಮನವಿ ಸಂಘದ ಪದಾಧಿಕಾರಿಗಳ ಸಮಕ್ಷಮ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಕಟ್ಟಿರುವ ಭಾಗಗಳನ್ನು ಅದೇ ಮಾಡಿ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
page 24 above the order. Annexure C.
Annexure C, page 24, internal page 7.
Internal page 7. Internal
First line. Okay.
First line.
Adhe,
Sorry. ಮೇಯರ್ ಮನವಿದಾರರ ಸಂಘದ ಪದಾಧಿಕಾರಿಗಳ ಸಮಕ್ಷಮ
come to a finding ಅಂದ್ರೆ ಆದೇಶವಾಗಿ ನೋಡ್ತಾ ಇದ್ದೀವಿ is different. Yes.
ಸಮಕ್ಷಮ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಕಟ್ಟಿರುವ ಭಾಗಗಳನ್ನು ಅಳತೆ ಮಾಡಿಕೊಂಡು ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಸಜರ್ ಮತ್ತು ನಕ್ಷೆ ತಯಾರು ಮಾಡಿಕೊಂಡು ಮೇಲ್ಮನವಿದಾರರ ಅಹವಾಲನ್ನು ಕೇಳಿ ತಾತ್ಕಾಲಿಕ ಆದೇಶವನ್ನು ಮಾಡಿ ಕಾರಣ ಕೇಳುವಂತೆ ತಿಳಿಸಿಕೊಡಬೇಕು. Here it contemplates that they will have to conduct their survey in the presence of notification. Then they will have to prepare the sketch. Thereafter, we shall be heard in the matter. After notes, they can issue the provisional order and show us notice calling upon us to notes furnish our explanation. This sort of notes has attained finality. Thereafter,
ಓದಿ ಆಮೇಲೆ ಓದಿ.
ಆದೇಶವನ್ನು ಮಾಡಿ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ಕೊಡಬೇಕು. ಒಂದು ವೇಳೆ ನಿಗದಿತ ಅವಧಿಯಲ್ಲಿ ಸಮಜಾಯಿಷಿ ಕೊಡದೇ ಇದ್ದರೆ ಎಎಂಸಿ ಕಾಯ್ದೆಗಳನ್ನು 120 ಸ್ಥಿರೀಕರಿಸಿದ ಆದೇಶ ಮಾಡುವುದು ವಾಪಸ್ ಸೂಕ್ತ ಮತ್ತು ನ್ಯಾಯಸಮ್ಮತವಾಗಿ ನಾವು ಅಭಿಪ್ರಾಯ. ಆದ್ದರಿಂದ ಈ ಸೂಕ್ತ ಕಾರಣಗಳನ್ನು ಸಕಾರಾತ್ಮಕವಾಗಿ ಪ್ರತಿ ಆದೇಶ ಮೇಲ್ಮನವಿದಾರರು ದಾಖಲು ಮಾಡುವ ಪುರಸ್ಕರಿಸಲಾಗಿದೆ. ಸದರಿ ಪ್ರಕರಣವನ್ನು ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ಪರಿಶೀಲಿಸಿ ಅಳತೆ ಮಾಡಿಕೊಂಡು ಕಚ್ಚಾ ನಶೀಲಿಯನ್ನು ತಯಾರು ಮಾಡಿಕೊಂಡು ಕಾನೂನಿನ ಪ್ರಕಾರ ತಾತ್ಕಾಲಿಕ
So 321(3) was set aside. 321(1) continued.
321(3) is set aside.
321(1) continued.
One notes, according to me, notes, since the observation is that they will have to issue one more notes of provisional order.
ಅದಕ್ಕೆ ನೀವು ಹೋದ ಕೇಳಿ.
All the three notes, though in the operative motion it says 321(3) is set aside, but ultimately it will not be binding.
ವಾಪಸ್ಸು ಕಳಿಸಿರ್ತಕ್ಕದ್ದು ಎದುರುದಾರರು ಕೆಎಂಸಿ ಕಾಯ್ದೆಯಲ್ಲಿ ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ಕೊಟ್ಟು ಪರಿಶೀಲಿಸಿ ಅಳತೆ ಮಾಡಿಕೊಂಡು
ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಹಾಜರು ಮತ್ತು ನಕ್ಷೆ ತಯಾರು ಮಾಡಿದ್ದು ಮೇಲ್ಮನವಿದಾರರ ಅಹವಾಲನ್ನು ಕೇಳಿ ತಾತ್ಕಾಲಿಕ ಆದೇಶ ಮಾಡಬೇಕು ಮಾಡಿ ಕಾರಣ ಕೇಳುವುದು.
It says that 321(1) continues, Mr. Guru. It is only that they are to inspect the property in your premises, make a sketch. And on that sketch, ask you for your further comments or reply, and then proceed.
The operating portion notes, it says 321(3).
Yes.
That is dated 7/8/2013 is set aside. But notes, if it is read along with the observation.
Allu nodi 321(3) ne ide. That is the reason why we asked you to read the entire thing.
Pending notes, third line notes, or otherwise notes, I read it only 3 lines notes from the top. ಮೇಲ್ಮನವಿದಾರರ ಸಂಘದ ಪದಾಧಿಕಾರಿಗಳ ಸಮಕ್ಷಮ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಕಟ್ಟಿರುವ ಭಾಗಗಳನ್ನು ಅಳತೆ ಮಾಡಿ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಮಹಾಜರ್ ಮತ್ತು ನಕ್ಷೆ ತಯಾರು ಮಾಡಿ ಮೇಲ್ಮನವಿದಾರರ ಅಹವಾಲನ್ನು ಕೇಳಿ ತಾತ್ಕಾಲಿಕ ಆದೇಶವನ್ನು ಮಾಡಿ ಕಾರಣ ಕೇಳುವ. It says you pass provisional order, issue Telecast. ತಾತ್ಕಾಲಿಕ ಆದೇಶ notes is provisional order.
Yes,
Then
let us see what is. Yes.
But after this notes, then once again notes issue the provisional order and notes the Telecast, for which notes we declare. Then they pass notes the confirmation order. Notes my responsible submission was apart from the deviations aspect of it. The order which is passed under section 321B needs to be set aside only on the ground that we have not been heard as directed with the Karnataka architect. But it says that Namma Ahavalan there are two issues. Samajayishi is objections or explanation to Lokas notice issued under section
Where is the 321 notice and what is the
321 is subsequently, that is dated annexure F.
Page?
2015.
page?
Page 28.
28.
Really not aware of plots that so far as the deviations are concerned, the deviations plots which can be compounded or plots which could be regulated or plots, some of the deviations which they have pointed out plots are not at all deviations as per the bylaws plots of the corporation.
Which is not a deviation.
Ultimately plots, my respectful submission is that
ನಿಮ್ ಸಮಜಾಯಿಷಿ ಏನ್ ಹೇಳಿ?
plots our basic plots our explanation at page number 31 annexure G. What's where the parameter 3 what's our objection is that in pursuance of the arbitration or passing the officials of the BPM visited the premises and took the measurements of the building, and they informed Sabha that they prepare the measure and scale in their office after considering all the objections made by Sabha at the time of measurement. They have not taken the signatures of any of the office bearers of Sabha and signatures for the sketch prepared by them. After that, they have not given us any copies of the measure or rough scale or proper scale said to have been prepared by them. Their plots, so far as their contention with regard to plots that the portico has come, certain plots, the stage enters are plots in violation plots. All those things are concerned. But bylaw 2.19 says porticos plots cannot be included under the covered area and the staircase. Bylaw plots 2.19 and 2.67. But all these plots aspects have not been taken into consideration. Plots, my submission plots is that your lordships are aware that so far as the Margosa road and Sampige road is concerned, plots in Malaysia. But it has got plots of two different plots, surface levels. So far as the Margosa road is concerned, plots it is on the higher side. The Sampige road plots is on the lowest. Plots, this property comes in between plots, these two roads. But the gradient level plots from the beginning or from the front side plots is leaning towards plots on the Sampige road side. It is not plots the same level surface.
What difference that would be?
The difference plots is that the height of the building or plots, the portico, that plots we have constructed or plots we have extended the slab. Surface parking plots need to be provided. But if I construct, then plots, if you have the gradient level plots leaning towards the Sampige, I will not be in a position to provide the surface parking unless and until plots I fill that particular area, either through the mud or plots putting a slab. But I will not be in a position to provide plots the surface car parking plot which is provided under the sanction plans. Now what they say is that they have taken into consideration the portico, they have taken into consideration the staircase, they have taken into consideration the slab also.
Where are the photographs? Which what area you are speaking of? Which are R2, na? These are two different buildings. Which area are you speaking of? Just to the road, Mr. Suman. Just to the road. Annexure R2, page 7. After the plan. First photograph on top.
But the road level because it's not properly.
Road level, Allapa, you are not giving surface parking there. It is it has come to the road.
Surface parking is there. Surface parking was in the portico.
Left side ಅಲ್ಲಿ ಇದೆ.
Left side.
That is a higher gradient anyway. Lower gradient ಅಲ್ಲಿ ಏನು ಕೊಟ್ಟಿಲ್ಲ. Forget the gradient, but the whole thing has come up to the road.
Portico roads that has been projected. Roads under the portico roads, what we have provided is the surface parking.
So that portico will have to be demolished.
Portico roads is not considered roads as the covered area under the bylaws.
So ಎಲ್ಲ ಮನೆ ಮುಂದೆ will build from the house to the road on portico.
What we
Is
have
that permissible, Mr. Subramanian?
what they have permitted for construction of portico roads that we have roads put up. So far as the surface parking is concerned.
Where is it permitted? Show us the plan.
Plan roads is
Where it is permitted to that extent.
right along the plan.
They have produced it at annexure R1. Second of February.
Yes.
20?
22.
Yes. Is the portico shown and where is it shown?
Pages. Yes. The elevation, then basement floor,
What do you want us to see?
then the ground floor. In the ground floor,
Second floor beka, first floor beka?
first page,
First page.
first page.
Yes. Where is the portico?
Existing ground floor plan. Second page,
What do you want us to see? First page or second page?
First page, I am referring to.
So our page ಹೇಳಿ, existing first floor plan, proposed second floor, proposed third floor.
Sorry.
This is what we have as first page.
Then what's in the second,
Yes. This is the portico. This thing.
That is shown as car parking.
Yes.
That is, that area of plots is above the basement.
Yes.
Plots, this we have covered plots, like in the slab because of the gradient. Is one permission.
The slab would be on the floor level, Mr.
Ground level. That is ground level. Since
You are
plots,
speaking
there was
of
a
portico
basement.
which is above the ground level.
Plots, that is true. That is true. No, I am only explaining that this above the basement, in order to provide this 3 surface car parking, we have put a slab. That is one. Total plots above this, the 3 surface parking area, we have plots, that area is open to sky. This particular plots, surface parking area.
Where is the portico on?
Portico plots is the
It is not shown
front
in
side,
this.
front, that is the front side.
So it is above this 4, 5 and 6.
Projection of first floor area.
It appears to be above 4, 5 and 6.
So the above plots 4, 5, 6. There is a projection plots, that is the portico.
Where is that sanction?
Then after that plots it is over.
Where is
What we
that?
have done plots is.
Where is that portico sanctioned, Mr.
Plots, I would only say plots that. But ultimately, what is there on the but it can only. Plots,
Subrahmanya, you appeared on this side.
Yes,
So you also know what it is.
Plots,
So
I am not saying that it was sanctioned. Plots, I only say plots that. It is only covering those 3 car parking areas plots we have erected the portico.
till now you said it is sanctioned. That's why we are asking you for that.
I am not saying it. So, it is moved to sky. We have not any obstruction over the portico. Once again, plots, it is as per the sanction plan. And what plots our submission is that since the portico covering plots cannot be construed plots as a covering area, plots are covered area as per the sanction plan. So that portico plots is only provided to protect plots the surface car parking.
If we accept your statement,
Yes.
in every house in Bangalore, in the front setbacks, people will construct and say this is only for protecting my car which is parked below it. If that kind of a submission is accepted,
Yes.
that would be the result. So there won't be a front setback at all, ever.
Here,
We can't accept that submission.
what's regularly done plots is that they project the portico across the property.
If it is
And they
regularly
also
done,
put up
all
the
of it
construction.
will have to go. It can't be regularly done like that.
I am only giving an example where plots the portico is low and thereafter plots they also put up construction. Here plots in our case, though portico is constructed,
You
but
are
we have
not
not put up the construction.
completely violated, you are partially violated an argument. The violation is a violation. You can't do that.
Apart from by calculating the front side, back side plots violations are. They plots commit a manifest error. Plots taking into consideration the back plots portion of the area as the frontage and the plots the back side of the site plots is considered as front plots portion of the building and plots the front is considered as the back. Plots they commit plots mistake with regard to the area which is to the left. But there is also a staircase erected there, plots that is to have a connection to the first floor, second floor, and third floor. But all these plots make only one sufficient.
Your contention basically is you have constructed a staircase in the setback area. Whether it connects whichever is a different thing.
Yes.
Can you have the staircase in the setback area?
Plots
You
for
cannot
the-
have.
Plots cannot be considered plots as a coverage area. Plots, but ultimately, so that the sanction plan is concerned, plots, what is permitted under the sanction? There's no question of lots, taking any.
Now sanction plan ಹೋದ್ರೆ you want regularly done ಅಂತೀರಾ. ಇವಾಗ ಇದಕ್ಕೆ ಬಂದ್ರೆ ನೀವು sanction plan ಅಂತೀರಾ. What do you want us to do? We'll have to go only by the sanction plan. You are in the front, you have constructed this portico which is not permissible, it is a covered area. On the left side, you have, on the right side, also you have covered the entire setback area. You can't do those things.
Lots that we have not used, except lots having a roof lot over this one. The car parking area. Against the lots above which lots no portico is constructed and it is over. This. Lots
Your contention, your instructions are contrary to the photographs, contrary to everything. So if it is contrary, then we'll have to say it is false. Basically, it's only the portico. Remove it. Remove that by yourself. Why do you want to keep that and create problem for your entire building? You should voluntarily come forward and do it. That's a bit you take action. If it is occupied without a OC, what do you have to do? You have to follow your law and you have to issue them note. Then they may come back before us, then we'll reject their prayer, that's all. That interim order will not come in your way of taking action as regard OC. It's a different matter which is pending. OC is not a matter of, you don't take action, people do whatever they want.
That is to be done first, then.
Kutilla, then ask them to vacate. If OC is not there, they have no business to occupy it. Guest floor is there?
It is a place where lots the under the.
Then more the reason that you have to follow the law.
Making for the public lots.
We cannot accept that.
Used by lots
No, Mr. Brown.
for a profit photo lots or as a commercial activity.
Then we'll have each resident coming and say, I'm using it for my house. I'm residing there, there's no profit. So don't apply the bylaws. If you are an institution carrying on religious activities, you are the first person to stand in the line to say, I am following the law.
I don't have any false lots with regard to that. Lots, your lordships are absolutely right. Lots.
That cannot be a
And
ground.
I am fully aware of lots. I am only not seeking indulgence of your lordship.
No indulgence can be granted. When will you demolish it?
But may make only one submission. Since there are certain issues lots, that require lots.
There is no issue whether you will demolish or they should demolish.
Lots may see lots 1 meter. Lots maybe lots you take up after 10 days. Lots lots have a lots visit so far as this property is concerned. Because lots there are certain issues with regard to the frontage and lots the back portion.
There is no issue with it.
Portico ಕಟ್ಟಿರೋದು ಬೇರೆ ಕಡೆ ಇದೆ ಅಂತ.
ನೀವು ಹೋಗಿ ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ವಲ್ಪ ಸರಿಯಾಗಿ ಬರ್ತಾ ಇಲ್ಲ. ನೀವು ನೋಡ್ಕೊಂಡು ಬನ್ನಿ.
ತಗೊಂಡೇ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ. But on the time lots certainly I am going to make this submission first. lots so far as the demolition of the portico lots are deviated. But I'm only seeking.
After seeing your, we'll give you that time.
Yeah.
After seeing your plan sanction, after seeing your photographs, it is clear that the front of the property
Yeah.
is completely covered. It is clear.
Not that they dispute. That is why lots I am.
ಅದೇ ನೀವು ನೀವು ಹೋಗಿ ನೋಡಿ. The photograph is very clear that it is up to the compound, up to the footpath in the front.
Front that is the lots.
ಅದೇ ರೀ ರೋಡ್ ಇರೋದು.
ಇಲ್ಲ ಎರಡು ಕಡೆ ರೋಡ್ ಇದೆ. Not this property has got lots.
ಆದರೆ ನೀವು ಎರಡು ಕಡೆನೂ you have to satisfy. If both side road ಅಂದ್ರೆ. That is what the bylaws say. If the corner property, then all of it has to be done. Please look into it. Then you will be in more trouble. Actually, then
The gradient level very.
gradient has nothing to do with this, Mr. Sudha.
That matters not so far as providing the surface parking.
We don't need to explain it, but we are explaining it to you. Is the gradient will have a bearing only as regards the slab above the cellar.
Yes.
It doesn't have anything to do with the portico or the cover made by you above that.
Yes.
So gradient has nothing to do with it. You are being.
Pausing here for a moment. This particular car parking or surface parking provided. Not on the slab overloads the basement. Everything is open to sky lots according to my instructions. What they have produced the
Your instructions are wrong and fair time.
But if that is the case, not certainly lots I would like to.
Your instructions are contrary to the photographs which are. If that instructions continue, then we'll have to say that the instructions are dishonest.
But I will not be making lots any statement.
Please go see the
Yes.
property
Yes.
and come back and tell us what it is. And more, you will have to come back and tell us when you are going, whether you will demolish or they'll have to demolish. You still have the option, you demolish it in a nice manner. Otherwise, if they come, they'll demolish it the way that they want and they'll charge you for it. So you'll have to do both. After arguing for some time, Shri R. Subramanian and counsel for the petitioner would seek for 10 days time to visit the property in question and verify if there is a portico or a projection on the ground floor of the property above the car parking area. As regards with the BBMP has indicated that there is a 90.6% violation. He is also directed to produce photographs of the said projection and the location thereof. And in the event of there being such a projection, to obtain instruction, make a submission as to whether the projection would be demolished by the petitioner. If so, he is directed, now direct means submission alert. When the said projection will be demolished. And the time frame released on 12th September. Clear agide, your instructions are wrong. She is going to submit that you would be filed. He has filed Vakaratnama yesterday. He seeks for 10 days time, for 2 weeks time to get ready and make submission. You file your objections? Mr. Sadashiva? Released on 15th September. Interim order that we are granted 31 and extended.
They have handed over to as per which order.
Which order?
That 21st July 2017. The response have seized by power plant, solar power plant, without having any authority, then they have opposed this order. This order was supposed to reach to past order. Two hand over to immediate effect and court has observed that I am entitled for damage of the period in which they have seized and locked my power plant. That is para two, phase 2 of the order.
Yes.
Last
Who appears for respond number 4, 3 and 4? ವಕಾಲತ್ ಇನ್ನ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
Earlier, they have complied the order and letter could have produced. They have issued letter also regarding handing over and they have approached.
They have been directed to take notice only on 11/8, Mr. Bhatt. Earlier it has been shown as AGA for 1 to 4.
Subsequent to that, copy has been served and they have not appeared. And it is EGS, they have issued letter in the year of 2017, which is 25/7/2017. And without.
When was notice issued?
Notice issued on 27/2017. Subsequent to that.
27.
20th.
27. There is no order of 20th 7. The first time the matter came up was on 21st July 2017. And only the HCGP appeared. Government advocate is directed to accept notice for respondent number 1 to 4 and inform respondent number 3 and 4 to remain present. Respondent number 3 and 4 were present on 28/17. And they unsealed the response. But there's no appearance on their behalf till that date. The only date on which after that it was listed was 23, and we directed Mr. Praveen to accept notice because the HCGP's name was shown. Now give them a copy.
Damage. That is the issue.
What do you want to do? You want to withdraw the petition? We'll dismiss the withdrawal.
No.
If they have to file their objection, you have to give them copy. We can't consider without giving them a copy. Counsel, that is what we have. The man was there for the petitioner. Let counsel for the petitioner is direct furnished 2 sets of the petition along with annexures on Shri Praveen Kumar. Shri Praveen Kumar seeks for and is granted 2 weeks time to file a statement of objection. He is also directed to specifically make the submission on behalf of respondent number 3 and 4 as per the contents of the order dated 21st July 2017. Objections, if any, to be filed on or before 21st, relist on 25th after serving advance copies, relist on 29th. First week. So to be filed on or before 29th, relist on 5th. N Praveen Kumar. Correct it as N Praveen Kumar. Correct agate. Yes. Counsel for response 1 and 2 seeks for and is granted 2 weeks time to obtain instruction notice submission. Released on 26th September. Copy. Counsel for the petitioner is direct furnish two sets of the petition along with annexes on the counsel for the respondent. Interim order earlier granted is extended. Vinod Reddy. Ashen.
37, I appear for respondent number 4 in this matter.
Then what is your allegation that they have not obtained that?
And they have also reversed my property.
Petition copy ne kodilla and papa, how can they make a summary? It was you have received the petition copy?
I have also not yet received the petition. Vakalat is also not.
How counsel for the petitioner is directed to furnish copies of the petition, two sets of petition along with annexes on each of the respondent counsel, who in turn seek for and are granted 3 weeks' time to file the respective statement of objections. Two sets. Objections, if any, to be filed on or before 29th September, released on 5th October.
Much of-
ಅವ್ರಿಗೂ ಕೊಡ್ಬೋದು, ಎಲ್ಲರಿಗೂ ಕೊಡಿ. ಒಂದು ಅವ್ರ ಹತ್ರ ಇರುತ್ತೆ, ಒಂದು will go to the department. Fifth.
I am for the respondents 1 and 2 matter notes.
In fact, I thought it was a good matter. Unfortunately, it was not closed on that day. And remove with the photographs was used in that case to show that it was a self-realization. The body, sorry.
ಇಲ್ಲಿ photographs ಎಲ್ಲಿ ಇದ್ರದ್ದು?
ಎರಡು ಒಂದೇ photographs. ಒಂದೇ ಹೊತ್ತಿಗೆ ಎರಡು piece.
ಎಲ್ಲಿದೆ? ಇಲ್ಲೆಲ್ಲಿದೆ?
Either in that matter I have produced, but I am club ಆಗಿದೆ. I'm sorry, in that I have produced.
ಇವತ್ತು ಗೊತ್ತಾಗಿತ್ತಲ್ಲ ಒಂದು ಕಾಪಿ ಕೊಡಕ್ಕೆ ಏನಂತ.
2011 photographs in that file.
How do we make out if you don't, if you say it is in some other file? Unless you produce, you can't get any benefit. If you don't produce, it's not there.
This covered paper, I have done the impression that since.
Covered, we'll have to see what that advertisement is about.
On the note, I have not used definitely advertisement charges, but the self-advertisement. Self-advertisement of the hotel.
Is it self-advertisement, Mr. Jagdishwara?
House self-advertisement. Illuminous.
Then it is covered. The petitioner is before this court seeking for the following news. The petitioner is running a hotel in the name and style of Mrs. Citrine Hotel at SC Road, Bangalore. The respondent had caused a demand on the petitioner to make payment of advertisement taxes on account of illuminated hoarding being erected by the petitioner on this property. The reply given by the petitioner was not accepted. The demand was confirmed and a demand notice came to be issued. It is challenging saying that the petitioner is before this court. The condition of the petitioner is that the illuminated hoarding put up by the petitioner on its property only reflected the name and business of the petitioner, and as such was relating to a self-advertisement and not an advertisement for a third party. This aspect is not controverted by the respondents. The list involved in the above matter has already been decided by this court in WP number 63533 of 2016 and other connected matters dated 27 June 2023. In that view of the matter, I pass the following order. Petition is allowed. Tertiary is issued. Notice dated 29/7. Is quashed. C, B, C, tertiary issued, so and so. D, tertiary issued, so and so. Any payments have been made?
And Lordship, in other matters, my lord, and the court had directed the concerned ERO to reconsider it, the objection statement made by them. That was the observation. In WP number 51275/15, which was disposed of 19/7/23.
If it is a self-advertisement, what is to be considered?
ಅದನ್ನ self advertisemental ಅಲ್ಲಿ ಮತ್ತೆ reconsider ಮಾಡಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ consider ಮಾಡಬೇಕು?
Our objections consider ಮಾಡಿದ್ರೆ that is the grounds of charges before this court.
Wash it, that's all. There's no reconsideration. If there's some dispute on self-advertisement, yes.
Please.
Portion for self-advertisement, portion for that andre ಹೇಳ್ಬೋದು.
Sir,
Otherwise, there's no point in remanding.
please.
R3 BBM. You are appearing for BBM. Respond number 2, Kengeri. Kengeri City Municipal Council. Respond number 2. Standing council ಯಾರು? CMC Kengeri.
ಇಲ್ಲ ಸರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ.
ದೇವರಾಜ್ ಕೆಂಗೇರಿ ಯಾರು? CMC ಕೆಂಗೇರಿ. ನೀವೇನಾ? ಯಾರು ಹೆಸರು ಬೇಕು? We'll issue a notice to you. Included in it. Shri Arvind M. Neglur, who appears for respond number 3, accepts notice for respond number 2 also. Registry direct print his name as. You are pleased. Counsel for the petitioner served. 2 sets of the petition along with annexures on Shri Arvind Neglur, who seeks for and is granted 3 weeks time to obtain instruction and make his submission. Released on 4th October. Objections, if any, to be filed by 29th September. ಅದು ಬಿಡಿ ಇದ್ರಲ್ಲಿ ಹೇಳಿ ನೀವೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಅಂತ. We understand council will be busy. You are ready in this matter. Okay. You sought for quashing. Tertiary was passed. What is V2? State by state. 76 FF and 321 A state. Page number. Last page is like. We'll reserve that liberty. The petitioner is before this court seeking for the following reasons. The petitioner has sought for regularization of the excess construction made by the petitioner in terms of section 76 FF of the Karnataka Town and Country Planning Act 1961. The said provision has been challenged is now pending before the Honorable Apex Court for consideration, where the effect of section 76 FF has been stayed. In that view of the matter, no order can be passed in the present matter. The petitioner is granted liberty to approach respondent number 3, depending on the outcome of the matter pending before the Honorable Apex. Until then, needless to say, until then, respondents would not be entitled to take any coercive steps against the petitioner.
Number 41.
Yes.
With regards to
Copy. Here was bigger. Last time you were not there.
copies of audit petition at the time of filing this.
No one could.
One other copy.
Counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexures on the counsel for respond number 2 to 4 by end of day 7th September. That counsel for response seeks for and is granted 2 weeks time thereafter to obtain instructions and file a statement of objections or make a submission. A statement of objection at file, the same to be filed on or before 29 September after serving copy on the counsel for the petition. Advance copy into the petitioner. Counsel for the petition. List on 5th September, October. Nimak bandidiya madam copy? And the respond number 2 to 4 on the counsels for the respondent, respective objections. Yes. Yes, Mr.
My lords, the writ may have to be allowed, man. There is no 321(2) notice issued by the corporation.
Commercial building was consisting of 3 floors.
Hmm.
Now, the lordship of kindness in the voucher, 3081 notice.
308 was issued, 321 is not issued.
321 the provisional order is not issued. Later, 321 3 is issued.
On the basis of 308.
On the basis of this, and even the 308 law.
Hmm.
The allegation is what we have converted basement for commercial space.
If they want to issue another 321, they can always issue another 321.
I just
Beginning
From 321.
because in the order they say you have violated first floor, second floor, another additional construction. They order. I have not been put on notice with regard to this aspect.
321 they'll have to issue. From 321 day, because 321 3 has happened, 3081. 3081 cannot replace 321
exact, my lord, that's the law, my lords. That's contrary to statute. Only one submission I have subject. I'm just putting it for my lords. Insofar as the deviations in the first, second, third floor are concerned, it has never been factually disputed by the petitioner, even in the appeal filed.
You issue them a notice. We are reserving liberty, let them reply to it.
Yes.
You have to take action, but do it in accordance with law, that's all.
Absolutely, my lords. Absolutely, yes.
One submission, after the construction was put up, they have widened the road. And for the widening, they have promised that they will be TDR. Now, that is also not, I have given a representation as well.
And if file another petition, we'll allow that. Like you have filed other petitions.
That's what I was thinking is last time. That's what they.
So that.
What will have to be considered is that a widened area, if there is a setback violation on account of the widening,
Yes.
that cannot be a violation.
ಅದಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ತಹಶೀಲ್ದಾರ್ has given an endorsement that there is no enforcement. That is their problem.
Alla, if there's a setback violation in the front on account of road, ಮುಂಚೆ ನೀವು 10 feet ಬಿಟ್ರೆ ಇವಾಗ 8 feet ತಗೊಂಡ್ರು 2 feet ಆಗುತ್ತೆ ಅಂತ that they cannot contest. That you can raise the ground.
If that there is no such allegation.
The petitioner is before this court seeking for the following relief. The short ground on which the petitioner is before this court is that a final confirmatory order under section 321(3) of the Karnataka Municipal Corporation Act 1976 has been passed without the issuance of a provisional order under section 321(1) of the KMC Act. The submission is that without issuance of a notice under section 321(1), the matter could not have been proceeded with and orders passed under section 321(3). The only notice which had been issued is under section 3081, which cannot replace or substitute the notice under section 321(1). This aspect has not been considered by the respondents or by the 6th Additional District and Sessions Judge D.K. Mangaluru in the impugned order. The substance in the submission made by Shri K. Anandrama, learned counsel for the petitioner. If any order is to be passed under section 321(3), it necessarily has to proceed with a notice under section 321(1) by complying with the requirements under section 321(1). The notice under section 3081 cannot be said to be in compliance with the requirements of section 321(1), nor can it be a substitute thereof. As such, I pass the following order. The petition is allowed. The impugned order and Annexure A dated 7/11/2011 in Miscellaneous Appeal so and so, and Annexure B in so and so is hereby quashed. Liberty is however reserved for the respondent to initiate such action as they may deem fit in accordance with law. All conditions are left over. It is totally unnecessary, 10 years of waste of time.
Swami, he told me on the last date and then I saw the papers. They said there is a notice. Notice ide ante ಹೇಳ್ತಾರೆ. It's written in invisible ink.
Officers have to take action in accordance. It appears that they have purposely taken in a wrong provision and such.
ನನಗೂ ಅದೇ ಅನ್ಸುತ್ತೆ. But I don't want to say anything about Anand's clients.
Last time we submitted TDR similar matter.
He said it's not similar matter and argued it. New similar matter ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ ನಾನು ಅಲ್ಲ ಅಂತ ಹೇಳ್ತೇನೆ.
ಏನಮ್ಮ? Yes. Post before a bench of which SGRJ is not a part.
My lord, I appear for R4, my lord. 46, my lord.
Normally ಈ ಕಡೆಯಿಂದ ಹೇಳ್ತಾರೆ, ಈ ಕಡೆಯಿಂದ ಬರ್ತಾ ಇದೆಲ್ಲ ಇದು.
Taken a plot in the note prepared by the respondent, and he himself is objecting for the order of the.
My lord, the petitioner has no locus standing challenge my appeal, my lord.
There is no interim order passed. There is no interim order. So you can go ahead do whatever if they are taking time.
My submission is the order of this respondent.
My lord, repetition is also not maintainable, my lord.
ಹೇಳಿ My colleague was asking time because you are not there. You are giving right.
There was no significant provided. The interconnecting is inter-class resolution. Yes,
Yes.
And thereafter she find appeal, and the inspection also find is objected, without considering objection of the appeal also. When the officer makes a seal the order. And the ground that the owner and the focus on the penalty, only development charges everything. And all.
What do you want? You don't want the layout to happen or?
That level, petitioner himself is right. In case of the, totally have to contest, to verify whether the layout is, it also, guided or this given. Panchayat does not take any steps. In fact, there is also.
Now the respondent number 4 has come forward to do it. He has paid the amounts which are required to be paid.
That is the say of the correspondent. The Panchayat has to take interest and verify whether.
That as a KD will direct. This relief is not proper. Mr. Rajendra, by when will you complete the layout works?
My lord, no, my lord, the respondent Panchayat, my lord, we have already deposited entire amount, development charges.
You madala.
ಅಲ್ಲ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ. Your lordship kindly see the my annexure.
The entire money, Mr. Naik.
Annexure R12, my lord.
Point number 3. Panchayat ಯಾರು ನೀವು ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ? ನೀವು ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀರಾ? ಯಾವಾಗ ಮಾಡ್ತೀರಾ? ಏನ್ ಮಾಡಿದ್ರಿ? ದುಡ್ಡು ಯಾವಾಗ ಕೊಟ್ರಿ ನೀವು ಮಿಸ್ಟರ್ ರಾಜೇಂದ್ರ?
My lord, I have produced the receipt also, my lord, annexure R2.
The respondent number 4 has to carry it. Annexure A, I have passed a resolution.
So now who will?
Respondent number 4 has to carry out the.
He is saying that he has deposited the entire money with
My lord, annexure R2, 3, 4, my lord. R2, 3 and 4, my lord.
As per the earlier permission, they are not developed that layout and ready. Panchayat also resolution.
My lord, on 3/5/2008.
Everything, anniversary and everything, the Karnataka Panchayat has settled that. They know that they have paid betterment charges, improve the layout. Now the petitioner himself purchased the site in that plot and that layout.
His grievance is the layout has not been formed properly and all the amenities have not been given. Now, have that been given or not?
Yes, Lord, I have given the approval, even the map is also approved.
Amenities ಆಗಿದೆಯಾ ಇಲ್ವಾ?
Amenities ಮಾಡಕ್ಕೆ respondent number 4 has to carry it out.
My lord, your lordship kindly see R12, my lord.
So will you do it or you won't do it?
My lord, your lordship, for a moment, my lord, kindly see R12.
R12.
Please, my lord, at page number 36.
ಹೇಳಿ.
Circular issued by the government. My lord, relevant para, my lord, at page 40.
Yes.
ಖಾಸಗಿ may read, my lord. ಖಾಸಗಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಅಭಿವೃದ್ಧಿಪಡಿಸುವಿಕೆ ಮತ್ತು ವಿನ್ಯಾಸಗಳಲ್ಲಿ ನಿವೇಶನಗಳನ್ನು ಬಿಡುವಿಕೆ ಷರತ್ತು ಕುರಿತು ಅನುಸರಿಸಬೇಕಾದ ವಿಧಾನದ ಕುರಿತು ವಿನ್ಯಾಸವನ್ನು my lord, ಫಸ್ಟ್ ವಿನ್ಯಾಸವನ್ನು ಬಿಡುಗಡೆ ಮಾಡುವಾಗ ಪ್ರಾರಂಭಿಕವಾಗಿ ವಿನ್ಯಾಸದ ಬೇರೆ ಬೇರೆ ಭಾಗಗಳಲ್ಲಿ ಚದುರಿದಂತೆ 60% ನಿವೇಶನಗಳನ್ನು ಬಿಡುಗಡೆ ಮಾಡತಕ್ಕದ್ದು. ಈ ರೀತಿ ಬಿಡುಗಡೆ ಮಾಡುವಾಗ ಅರ್ಜಿದಾರರು ವಿನ್ಯಾಸವನ್ನು 2 ವರ್ಷದೊಳಗಾಗಿ ಅಥವಾ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯು ನಿಗದಿಪಡಿಸುವ ಅವಧಿ 5 ವರ್ಷಕ್ಕೆ ಮೀರಿರಕೂಡದು ಅಭಿವೃದ್ಧಿ ಪಡಿಸತಕ್ಕದ್ದು. ಸೆಕೆಂಡ್ ಮೇಲಾಡಿ ಉಳಿದ 40% ನಿವೇಶನಗಳನ್ನು ವಿನ್ಯಾಸ ಸಂಪೂರ್ಣವಾಗಿ ಅಭಿವೃದ್ಧಿಗೊಂಡ ನಂತರ ಬಿಡುಗಡೆಗೊಳಿಸುವುದು. ಥರ್ಡ್ ಮೇಲಾಡಿ ದಿಸ್ ಇಸ್ ರಿಲೆವೆಂಟ್ ಮೇಲಾಡಿ. ಈ ನಿಗದಿತ ಅವಧಿಯೊಳಗೆ ವಿನ್ಯಾಸ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಗಳನ್ನು ವಿನ್ಯಾಸದ ಮಾಲೀಕರು ಪೂರ್ಣಗೊಳಿಸದೇ ಇದ್ದಲ್ಲಿ ಉಳಿದ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಗಳನ್ನು ಆಯಾ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯೇ ಕೈಗೊಳ್ಳತಕ್ಕದ್ದು. ಇದಕ್ಕೆ ತಗುಲುವ ವೆಚ್ಚವನ್ನು ಉಳಿದ 40% ನಿವೇಶನಗಳನ್ನು ಮಾರಿ ಬಂದ ಹಣದಿಂದ ಭರಿಸತಕ್ಕದ್ದು. ಈ ರೀತಿಯಾಗಿ ವಿನ್ಯಾಸ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ನಂತರ ಉಳಿಯಬಹುದಾದ ಮೊತ್ತವನ್ನು ವಿನ್ಯಾಸದ ಮಾಲೀಕರಿಗೆ ಹಿಂತಿರುಗಿಸತಕ್ಕದ್ದು. ಇದಕ್ಕೆ ಅನುವಾಗಲು ವಿನ್ಯಾಸದ ಮಾಲೀಕರು ಮೇಲಿನ ಷರತ್ತು ಅನುಸರಿಸದೇ ಇದ್ದಲ್ಲಿ ಉಳಿದ 40% ನಿವೇಶನಗಳನ್ನು ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳಿಗೆ ಪುಕ್ಕಟೆಯಾಗಿ ಹಸ್ತಾಂತರಿಸುವ ಕುರಿತು ಮುಚ್ಚಳಿಕೆ ಪತ್ರ ಬರೆದು ಕೊಡತಕ್ಕದ್ದು. ನೆಕ್ಸ್ಟ್ ಮೇಲೆ ವಿನ್ಯಾಸಗಳ ನಿವೇಶನಗಳ ಬಿಡುಗಡೆ ಮಾಡುವಾಗ ಬಿಡುಗಡೆಯ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ನಿವೇಶನಗಳ ಚೆಕ್ಕುಬಂದಿ ಅಳತೆಯ ಸ್ಫಟವನ್ನು ನಮೂದಿಸಿ ಸುತ್ತಲೇ ಲಗಸಿದ ನಮೂನೆಗಳಿಗೆ ಮೈಲಾಡ್ ದೇ ಹ್ಯಾವ್ ಕಲೆಕ್ಟೆಡ್ ದಿ ಎಂಟೈರ್ ಡೆವಲಪ್ಮೆಂಟ್ ಚಾರ್ಜಸ್ ಮೈಲಾಡ್. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಖಂಡಿಸಿ
Development charges have to be paid. That has nothing to do with layout formation. Your new layout complete ಮಾಡಿದಿರೋ ಎಷ್ಟು percentage of sites ನೀವು ರಿಲೀಸ್ ಆಗಿದೆ ನಿಮಗೆ?
My lord, I will get the instruction, my lord, next week.
If it is 60% only, 40% will get forfeited to the panchayat. And from that sale, they can do it.
Please, my
You
lord,
have to give that amount in terms of section 35 of the KTCP Act.
My lord, in that regard, my lord, I get the instruction, my lord, kindly have it next week, any date, my lord.
After arguing for some time, Shri S. Rajendra Learned Council appearing for respond number 4 seeks for and is granted a week's time to obtain instructions from his client as to whether respond number 4 would be providing all the amenities to the layout, since admittedly the layout formation is not complete and all the amenities have not been provided. The respond number 3 is respond number 3 and respond number 4 are also directed to place on record as to what percentage of sites, how many sites have been formed, how many sites have been released, and how many sites have been sold to third parties in the said layout. Relist on 8th September.
Oblige, my lord.
Yaudu. 47. Where counsel for the petitioner has filed a memo dated so and so, signed by the counsel for the petitioner, seeking permission for withdrawal of the above matter. Accepting the said memo and the submission, petition is dismissed as withdrawn. Sale number? Yes. Have you informed the others? Just a minute. One dadmel one. 58. Shri KB Monish Kumar has entered appearance for respond number 2. Delete the name of Pawan Kumar for respond number 2. Same 2 paras. Shri Monish Kumar seeks for and is granted 2 weeks time to make a submission. Relist on 15th September. Have you informed them? 54. Learned counsel for the petitioner seeks for and is granted a week's time to go through the objections filed today and make a submission. Relist on 15th. Yes.
Next week.
52 at the request of counsel for the petitioner, relist on 8th September.
Plus 51. Seniors signal that he is not well. You inform the other side.
You are appearing for whom first?
For R2.
R2. At the request of counsel for respond number 2, relist on 8th September. Interim order earlier granted is extended. 69 at the request of counsel for respond, relist on 8th, 9th. Interim order earlier granted is extended. 65? 65, one year correct. Ian 65, Ian, who are you for? Yes, what do you want? We inform the respondent. Yeah, Mr. Bandari. 65, inform Madi. At the request of the council for the petitioner released on 15 September. 68. Inyavadu? 68 ಅಲ್ಲಿ ಯಾರು? 65 is Dhananjay Kumar. 68 is Mr. Rajshekhar, yes. Not your matter.
ಸಮಾಧಾನ ಪಡ್ಕೊಳಂಗೆ ಯಾವ್ದಾದ್ರು ಕೋರ್ಟ್ ಬರೀಲ್ಲ ಅಂದ್ರೆ ಸಾಕು. ಎಲ್ಲ ನೋಡಪ್ಪ ಇಂಚಿಗೆ ತಪ್ಪಾರ್ದ ಹುಟ್ಟಿದ್ರ ಹೋಗಿಪ್ಪ ಇಲ್ಲ ನೀವು
ಇಲ್ಲ ನನಗೆ ಯಾವ್ದೇನು
ಇಂಚಿಗೆ ತಪ್ಪ ಬರ್ತಿದ್ದಾರೆ ಎಲ್ಲ ಎಲ್ಲೇನೆ ಎಲ್ಲ ತಪ್ಪ ಬರ್ತಿದ್ದಾರೆ
ಅದಕ್ಕೆಂದಲೇ ಕುದುರೆ
Yes.
WP number 201004 of 2021 is allowed. The impugned judgment in MA number 39 of 2018 dated 27/2020 is quashed, and the order allowing IA number 1 dated 17/9/2018 in OS number 759 of 2017 is set aside. IA 1 is dismissed. WP number 201240 of 2023 stands dismissed.
Please.
You received possession. You received possession. Have you received possession? Have you received possession?
No, the possession has been wanted. Issuance of notice I have approved this night. Next day. Subsequently, they have pardoned disorder, they have been able to take sub-act. By giving the work order, is the respond number 4 in the then the position they were not taken. In spite of the there is an order in their own case that no further proceedings will be done. But by violating that, they have taken the position with the forceful police help. On 24th, the 24A, who then they have intentionally contacted the interim order, then they have become the petitioner in the other case. specific order by this honorable court that we should not proceed with the case. There is not, there is not. Terminating the work order in favor of petitioner settlement. In spite of the order, he has continued, he has finished 11 months as per their own work order.
Who is completed 11 months? Who has completed 11 months?
The petitioner is the first matter.
Ah.
So now they have the DPSP has three notices terminating his service after completion of his work order earlier. So now the work order has been terminated and given to the petitioner the another day.
We'll have to hear both. No, we'll have to hear both of you because he's saying the other prayer number 2 survives. So we'll have to hear both of you. Tell us when you'll be ready to address that. If you're ready, we'll take it now. Ready?
In my case,
So you're ready today? You argue the matter. We'll consider that when we hear the matter. Both the council speaks for and are granted a week's time to get ready and address the arguments.
also operated in their case.
Released on 8th September, interim order earlier granted and extended till next date. Both. Common order. Now interim order is there, extend, we are not varying it now. We'll hear both of you. Mr. Reddy, if you are ready to address arguments today. Then address arguments today. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಂದ್ರೆ ಟೈಮ್ ಬೇಕು ಅಂತೀರಾ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ. We are ready to take it up. ನೀವೇ ಶಾರ್ಟ್ ಡೇಟ್ Vinod Reddy. None appears for the petitioner. Go for it twice, once in the morning session, once in the afternoon session. Below the order sheet indicates that none has been appearing for the petitioner. On earlier occasions also, it appears that the petitioner is not interested in prosecuting the matter. Petition.
Yep. Claim is done on the. And they trust and retention mark put up and it has been brought into the legal of this. Because I think if admitted to fight or complaint.
What is the compliance you are filing?
eastern side. Upper retention wall. And every incident has been carried.
Yes.
Exact position, one latest position. Photographs are taken yesterday. That photograph was. Number 3. What's the other half? The second half. The compound wall is not completely built. Because you can see this new construction. And towards the end, there's a breakage. And due to the excavation work done by them, there's a crack, entire crack on the door on the other side. And they have not completed that, and the sump has been completely damaged by the excavation done by them. And it has not been restored to. There's an order from this order to bring it to the original position. So by writing this complaint report only after the lordship has directed.
Have you seen the photograph? Have you seen this photograph?
Yes, ma'am. It is totally on other side. Not kindly as per the photograph produced at annex of the series melon. That is was noticed by on the court melon. Accordingly, estimation was done.
Annexure?
Series next to be
Clean. Here they have photographs.
towards eastern side melon. P1, P2, P3 melon. It says clearly that was P4 was created due to nature of soil melon. That was filled up and the retention was has been constructed.
You are appearing for whom?
Respond number 3. Direction to me may not construct at the cost of respondent number 4. That's why
That's why you are not constructed as per what was directed.
we do not submitted estimation of that and they did not object that.
ನೀವು ಎಸ್ಟಿಮೇಶನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಕೆಲಸ ಮಾಡಿಲ್ಲ ಸರಿಯಾಗಿ.
Till end the photographs ಪ್ರಕಾರ ನಾವು construction ಮಾಡಿ.
Please see page 5 of their memo now that they have filed.
This bill is some this old and it appears to be. The retention was.
Mr. Council, when you are building this compound wall after demolishing, it has to be built properly. Is this how you build?
I think it is not the cause of construction. It appears to be old something. They have produced some other
Sorry,
photograph.
in that case, a commissioner will appointed any of the colleagues.
Yeah, we are really, we'll have to use the word shock that you are making that kind of a submission. How can you even make that kind of a submission? When you yourself have demolished the entire wall and built it like this, and it's something else and teltiralla.
Demolished by respondent number 4.
You are tasked with building.
Not demolished, my lord, that is where the commenced construction work. The P4 was created. That was built up and the retention was.
ನಿಮ್ಮ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತೀವಿ. ನೀವು ಆ ವಾಲ್ ಕಟ್ಟಿದೀರಾ ಅಲ್ವಾ? ಕಟ್ಟದ ಫುಲ್ ಕಟ್ಬೇಕು ತಾನೆ. ಒಂದ್ ಎಂಡಿಂದ ಇನ್ನೊಂದ್ ಎಂಡ್ ವರೆಗೂ ಕಟ್ಟಬೇಕು. ಪೇಜ್ 5 ನೋಡಿ ಹೆಂಗ್ ಕಟ್ಟಿದೀರಾ ಅಂತ. Number one. Number two, a crack ಆಗಿರೋದು ಯಾರು ರಿಪೇರ್ ಮಾಡ್ತಾರೆ? ಸಂಪ್ ಇದೆ, ಅದು ಎಲ್ಲ ಕ್ರ್ಯಾಕ್ ಆಗಿ ಏನೇನೋ ಆಗೋಗಿದೆ, ಅದು ಯಾರು ಮಾಡ್ತಾರೆ? That is what you are supposed to do. What have you been doing for last 4 months? So now come and say that you are going to look into it. What have you been doing for last 4 months? You don't even appear, no compliance report is filed, and now you file something half-heartedly. This is how you do it. You have to call for that officer to be present, because there is nothing which is filed by you. Is that what regard you have for the orders of the court? We are not concerned whether somebody is transferred or not. The order was passed by a coordinate bench earlier. That means that it has to go there only. Nobody can do anything with it. We are concerned with implementation of the order passed by this court. And you are an authority who has to implement it. You cannot have this excuse of person is transferred and do some haphazard work. Can that be there? Look at the kind of construction you've done. Nodi, and the construction anga madadu. Ascertain alla construction ಮಾಡಿ ಮುಗಿಸಿ ascertain ಏನ್ ಬಂತು? You have whatever was part of it was damaged. You have demolished the entire compound wall and redid the entire compound wall. Nodi photographs nodi illa instructions tagolli correct agi. Hosa wall adu construct ಮಾಡಿರೋದು. From this end to that. Last ಅಲ್ಲಿ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ. ಅದು ಯಾರು ಮಾಡಬೇಕು? ಇವ್ರು ಹೋಗಿದ್ರೆ ಮತ್ತೆ ಅವರಿಬ್ಬರಲ್ಲಿ ಜಗಳ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಹೇಳಿದ್ದು ನೀವು ಹಿಂಗ್ ಮಾಡ್ತೀರಾ? ಅದು ಬರ್ಬೇಕಾಯ್ತು, ಪೊಲೀಸರು ಕೊಡ್ತಾ ಇದ್ವಿ. If they are not, what is Mr. Binod? Why are you stopping them from doing it? There are still these 3 things to be done. How ಮಾಡ್ತೀರಾ? ಏನಂತ ascertain ಮಾಡಿ? Okay, tell us
Because of this damage ಆಗಿರೋದು earlier this how to ascertain that?
You ascertain and file a report. Let us see how you will ascertain that also. And file an affidavit as to who has demolished this compound wall and built it. Please file it. We'll deal with it. If you want to ascertain, please ascertain. We'll give you a week's time. Ascertain, file an affidavit. Also file an affidavit as to who has demolished this and who has built this. According to us, that is enough for having not completed the work. There is no ascertainment. If you want to ascertain and file, we don't know what you are going to file, but file. ಕೆಲಸ ಇದೆ ಮುಗಿಸೋದು ಬಿಟ್ಟು you are coming up with all these. ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತೀರಾ? You are inviting the court to pass orders. Instead of completing your work, you are coming up with these excuses which will require us to take it up seriously. Please do that. Mistake agide, okay, accept the mistake and finish it. Don't keep on giving these excuses.
There are some sort of authorities.
Once there is an order passed and once you had filed the estimate, it covered all these things which you had to do. It's your call. We'll give you a week's time. Whatever you want to ascertain and file. On being pointed out from the photographs that the work carried out by respondent number 3 has not been completed properly, in as much as the portion of the wall towards the back of the property, towards the rear of the property of the petitioner has not been completed, and that there is a gaping hole, as also there are cracks therein. Apart therefrom, the damage which has been caused to the sump tank has not been repaired. The counsel for respondent number 3 seeks for a short accommodation to ascertain and file an affidavit of the concerned officer as to the cause of such damage, who has demolished the compound wall and rebuilt it, and if any work is left out, when the same would be completed. Released on 8th September. The third respondent shall be present on that day also. The state I release the name of T. Shankar Reddy and retain the name of P. Rohit Vijay. Madam, where is the chairman? Where is the chairman? We are not concerned with it. Where is the chairman? He is asked to be present. It took 15 days for you to pass an order. We are not excused his presence. Available warrant. Despite the order dated, sorry. Is he there, not there? Okay. What are you planning to do now? What do you want to do now? This is order you have passed. ಓದಿ ಏನಾರು ಹಂಗ ಆರ್ಡರ್ ಇದೆಯಾ? ನಮ್ಮ ಆರ್ಡರ್ ಏನಾದ್ರು ಇದೆಯಾ? ಏನಂತ ಬರುತ್ತೆ? ನೀಡುವ ನಿರ್ದೇಶನದಂತೆ ಎಲ್ಲಿ ನಿರ್ದೇಶನ ಕೊಡಿ, ನಾವು ಹೋಗಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ. Examination ಮಾಡಕ್ಕೆ you are taken 15 days. There is nothing which says here whether the tree is causing damage or not. Oh, they themselves say, and it took 14 days for this, 15 days. If the tree had fallen down, what would have happened to them? Would you have built the house and given to them? There has to be some humanity. And your officer doesn't even come. It's not the way it is done. Make an observation, that's all. That doesn't absolve him of his responsibility. There's complete abdication for the last 15 days. He will go into his ACR. So when will you do this? When it council for respond number 1 to 3 has filed a memo enclosing an order dated 1/9/2023. In the said order, it has been categorically stated that the tree in question has leaned against the property of the petitioner, and further that it's likely to topple or fall onto the property of the petitioner, as also which could result in harm and injury to the petitioner's property, as also the general public. The petition had been filed on 14th August due to non-consideration of a representation dated 25/7/2023. Finally, the order has been passed on 1/9/2023 after a delay of more than 36 days. It is rather shocking that the respondents have not taken any action when the tree posed such a dangerous situation for 36 days. If the tree had indeed toppled onto the property of the petitioner, there could have been damage caused not only to property, but harm caused to the life and liberty of the petitioner and his family members, which has been completely overlooked by the respondents. Despite the order dated 31/8/2023, the respondent, respond number? Respond number the chairman of the tree committee is also not before this court, and no exemption has been filed. Who does he report to? Who does the report to? What is his designation? He Principal Chief, the Principal Chief Conservator of Forest is directed to look into the matter and cause such entries as may be required in the ACR of the Chairman of the Tree Committee. To report, Learned Counsel for Respondent 1 to 3 submits that in furtherance of the order dated 1/9/2023, the cutting of the tree will be carried out tomorrow. That is, you are passing the buck again. You are passing the buck again. It is your responsibility. Madam, it's a tree which can fall over their house. Imagine if that was the situation with you. And a tree was falling over your house, what would happen? If your officers were to say, neighbor has to do this, that has to happen, does that neighbor even have the wherewithal to cut this tree? It has to be done in a scientific manner.
Yes.
Please don't pass the buck. This has to be done in a scientific manner. You have to do it. He only wants the wood. He wants the money for that. Give him that. Give him the wood. But you cut it. The Council for Respondent number 1 to 3 submit that the neighbor of the petitioner has been granted permission to cut the tree. I will consider opinion that the same again is another abdication of responsibility on part of the respondents, inasmuch as it is the duty of the respondents to protect the citizens from any harm that may be caused to them. The respondents cannot transfer their functions to a private party. The tree, as can be seen, is a large tree which is leaned over to the property of the petitioner. And the cutting of the said tree would require proper scientific methodology to be adopted, which a private person like the neighbor of the petitioner may not have. Thus, it is for the respondent number 3 to do the needful in such a manner as not to cause any harm to the do the needful in a matter and cut the tree in such a manner as not to cause any harm to the property of the petitioner, and in the event of any damage being caused, to rectify the same. The application which had been made by the neighbor of the petitioner was apparently only with the intention to make use of the wood derived from cutting of the tree. If that be so, the respondents can always hand over the tree which has been cut to the neighbor. The respondent number 3 is directed to carry out the order dated 1/9/2023 of the respondent number 3, commencing from 10:30 AM on 2nd September 2023, and complete the same at the earliest in a proper and scientific manner. In the event of the necessary equipment not being available on 2nd September, the equipment to be sourced at the earliest and needful to be done. ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗಿ ಕೊಡ್ಲಿ ತಗೊಂಡು ಹೊಡಿಬೇಡಿ, ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ. On 7th September for reporting compliance. Please ask your officers that they are there to take care of the citizens. 25/7 in the Ingidre meet. ಇದ್ದೋಗಿದ್ರೆ ಅಷ್ಟೇ ಮುಗ್ದೋಗಿರೋದು ಅಂತ ಕತೆ. All of you would have been in the dock. We're lucky that nothing has happened.
Corrected by the
No help. ಅವ್ರಿಗೆ help ಬೇಕಾಗಿಲ್ಲ. ಇದ್ರಲ್ಲಿ ಬೇಕು. ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿ ಇವಾಗ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಸೀನ್ ಆಯ್ತು ಅವ್ನಿಲ್ಲ ಹೆಂಗಿತ್ತು. That's the only issue with this. We have already passed an order on that, but still Mr. Datta has raised the issue that the earlier judgment was by a full bench in this one, in Pandapura. Now the declaration which has happened, which we have accepted in another matter. We have accepted it, but right or wrong, we'll have to again look into it on the basis of Mr. Datta's submission. That once a larger bench has declared the law, can a smaller bench declare that that law is not applicable? Is the submission of Mr. Datta.
You are exactly right. Only public trust case that we have been confronted with the same situation. There one of the and the state there to the county. So therefore, they start question now. What is meant by goal? What is meant by the departure from state decision and reconsideration of state decision? These are all different types. Now, so far as the overruling is concerned, the decision may be over a question of law which has been taken has been overruled by the court. The effect of would be what is overruled is the principle of law later in the not an extent. That's the distinction. That is what happened. Therefore, what is overruled is by the but still, PVR case is bound by the principle of tragedy. So far as overruling is concerned, they are bound by the principle of precedent. That is all. I just wanted to read a few passages now.
ಕೂತ್ಕೊಳ್ಳಿ ಯಾಕೆ
And there is a very good passage in common law case. Following the American, how the principle of state decision will be departed. The principle of state is applicable where the legislature would not enter. But if the legislature has got a right to enter, then the field of state decision is restricted. And just read only two paragraphs. And one state demand 24 hours so that
if you want some, because this is the issue. So if we have heard in the earlier order by holding that, we'll correct it. Because Mr. Datta is saying, yes, but only, see, whatever, nammalli enagutte, whatever is argued before us, we'll consider that. And whatever comes to our mind at that time. There may be, everything doesn't come to us at that
in
time.
all cases, this question of law is not solved.
kindly take that paragraph
Para?
48.2 and put up that at page 59. There are 48 as district.
Yes, we got it, but it starts with, therefore, there are two limitations. This
Yes.
limitations is for what? Any particular thing which has been raised. at all?
Second limitation. Second limitation. But overruling the opinion of the single does not constitute city in a case, but is done only in exceptional circumstances, such as when the earlier decision is very good or is delivered in the absence of the president, or if it is manifestly wrong and capable of causing public mischief. For this proposition, the court relied upon the judgment in Islamic, where it was said that when Article 141 lays down that the law declared by this court shall be binding on all within the territory, it quite obviously refers to the court other than this court, and that the court would normally follow past precedent, say, and except where it was necessary to determine the correctness of law later in that judgment. In fact, this is important. In fact, the overruling of the principle of law is not an outcome of appellate jurisdiction, but a consequence of the inherent power. This inherent power can be exercised as long as a previous decree established this inter parties other. It is an attempt to overcome the decision of a previous case that is problematic, which is why the court observed under the Constitution that the appellate jurisdiction does not vest in this court, nor it can be vested by the president of the the controversy between the parties and the decision operated at the city. And it was required that the discretion under Article 1. It has also been observed that this court has analyzed the relevant court. Therefore, has to stand into the person of that or part of the until the was there that the airport manifest that the court has clearly not the days of the people now, what is a larger bench overrules the particular bench. It overrules the principle unless your lordships in paragraph 55. All the judgments which have been rendered up till today, contrary to the margin, it ceases to operate as a city.
Yeah, the finding specifically in that.
Unless the paragraph 55 of explicit or the other area is that prospective overruling is a constant statement in our. But in only 3-4 judgments, unless and until the apex court has laid down that the judgment of the apex court is prospective in character, it will have a retrospective effect from the date on which the statute is interpreted before an apex. So these are all where the principle is overruled. But the judgment would be binding on the party. That's the first principle. So the second principle.
It is not in appellate jurisdiction.
Yes, it is an inherent. If a list is between the parties, binds on it. Of course, the first judgment I could not get all in it. If I remember 66, is what is the main authority that I will assist. Then the judgment of my lord K. Jagannath is there. I think it is 78, single batch. I will not give all that. But all these judgments would say that a decision may be overruled in another case by a larger bench.
The principle.
Yes, what is overruled is the principle and not the decision between the parties. Still, the parties are governed by a decision between the parties. Even the apex person, even the president of India, article 143.
KVR Shetty.
That KVR Shetty, just one. But I was also alert. Our Noor, I know several cases like. Of course, we did not, though we were there, but we have assisted the clear. Not what the division makes them. I'm just not there. Under section 45C of the Road Transport Corporation. The power to make the regulation is conferred. So therefore, once the regulations are read and notified, then the other the bar was, unless you come out of 13B notification, you have no power to make 45. That's not a question. Then paragraph 13, the two notifications were not required. Literally speaking, it is incorrect by applying the principle of literal interpretation. Because unless you take it out yourself from the Industrial Employment Standing Orders Act of 1946, you have no power to make the regulation. That's the point. Even if you make the regulation between the industrial employment and the statute, this will provide because this. Then the question was, you have also made the regulation under 45. It's also a central. It is also an industrial employment. Then the general legislation, the special legislation, but ultimately that when 45 is notification regulation and it got notified in the official gazette, it is deemed to have been taken out from 13B. That is the import of this. There is one more other angle. If a judgment is delivered by the court of a state or a local legislation, if it is in force for the decision is there for more than 1 decade, 2 decades, 3 decades, such a principle cannot be disturbed.
Is what the division bench says later.
Yes, that is one of them. So therefore, this full bench judgment is there. KVR Shetty's case is not correctly decided. Is only that the state decisions should be restricted only so far as interpretation of law. But it cannot affect a decision between the two parties. It continues to bind KVR and the regulations.
But here we don't have those parties. We have different parties before us.
Yes.
So if it was same parties, it is clear.
So in fact, I think the entire, except our judgment, 2017.
We'll have it another day.
Yes.
Come prepared with that.
No,
Please share the judgments also with the other side.
Yes.
So they can also look into it and then make their submission.
I will assist the last. One is, I just wanted the woman of case. So after the Supreme Court whether you are a party to the judgment of. That is also Miller. Data. Whether a contention should have been raised, the decision of the apex court or the constitutional court would have been like this. Whether I am a party to it or not. So these questions will not come, but you are bound by that decision. That's the law. So therefore, I am not a party to it. Therefore, that judgment would not be binding. And a particular argument was not raised nor conceived by the bench. Therefore, the decision has no their precedential value. That also is considered. So here, the decision which is in force for more than 4.5 hours, interpreted by the local legislature. And there is one more decision of the so far as a decision rendered by the local legislature, especially in respect of the condition of service, which is in force, then such a decision cannot be disturbed so late. In fact, there are three aspects. A state decision, when it to say that a state decision, a ratio decision followed in number of cases consistently without a departure of principle, it becomes state decision. Then how to depart from the state decision? That is one aspect. It is only in public interest. Uncertainty, the court is confronted with a compulsion, the object in the public interest. Then only court can try to reconsider. It is not the basis for reconsideration. It tries to reconsider, keeping in the public interest and keeping in the mind that certain things cannot be unsettled, especially in contractual matters. You are aware of it. In 1990, Punjab National case, by Constitution, read that so far as the overruling in Raghuveer Singh case of the 89th Supreme Court, land acquisition, overruling is principally applicable. Overruling, before that, you wanted to have an area of reconsideration. Reconsideration of a certain principle, state decision. So before that, we must find out what exactly the ratio decision. But ratio decision, just ask me, data, the three principles of 79. The ratio decision mean the facts of the case, the legal controversy confronted in a case keeping in the legal position. Then upon an interpretation, the law which has been laid, anything which is not necessary to lay down the law,
Not declared to be laid down.
Yes.
Not just
Yes.
the finding,
These are the three
the
principles
Lord declared.
I'll just read those principles. And that is how it has been laid down. Then, if it becomes a state decision, I can say this KVR set is state, which fell for consideration subsequently more than one activity. If it is a validity of a legislative rule making power, it is not a case of individual fact, the case has been laid. It is a question of the rule making authority, the rules were in force for more than 4 years. After the interpretation, therefore, it becomes number of cases have been decided based on this.
Yes.
Now, many things have been settled. So therefore, it becomes that I will just read Miller, the Waman Das case. I just but reading one paragraph.
Yes, please.
Paragraph 40.4. Sorry, I will start here. Paragraph 39. These decisions and texts are of high authority and cannot be overruled. In fact, these decisions are themselves precedent on the binding nature of this. It is also true to say that in application of the rule of state decision, it is not necessarily that the earlier decision or decision of long standing should have considered and either accept or reject a particular argument in the case of. Were it so, the previous decision would more easily be treated as a problem. And it may unnecessary to take the start of this first step. It is therefore sufficient for invoking the rule of state that a certain decision was arrived at a question which arose or occurred, no matter on what reason the decision died or what is the basis of the decision. For the purpose of applying the rule of state, it is unnecessary to inquire or determine as to what was the rationale of the earlier decision, which is yet to operate as a decision. But kindly apply this to the KVR case. Therefore, the reason why Article 31A was upheld earlier, if indeed it was or not germane for the purpose of telling that this is a bit of a proper case in which to apply. But there are four principal reasons why it was not discussed, but deciding upon constitutional perspective. In the first place, Article 31 treats its own vitality, drawing its sustenance from the basic tenets of the Constitution. Its unstated provision is an integral part of the very making of the Constitution. It goes, as it were, a mirror to the ideals, part of the. The second reason why we do not want to start the by determining the validity of the neither a central response nor evidently not intentional, but the person are very absent of article 31 as stated earlier. Shampoo Prasad involved larger person of constitutional amendment for within the 30 of it was also had that the surgeon and demand legal stage that is the board was not inclined to consider constitutional amendment also compared within the term. Goloknath raised the question as to where the amending power is located and not whether this or the particular amendment. None of these decisions were the validity of the student, nor it was the question. A deliberate judicial decision made after hearing an argument and a question with the right or a put in issue, a constituted precedent that this is important. And the precedent by long recognition may mature into state. But these cases cannot consider it reasons are First Amendment. Thirdly, the history of the world constitutional law shows that the principle of state is treated as having a limited application. Justice William Douglas, that is New York Constitution, that it is a wise policy to restrict the principle of state is those areas of the law where correction can be made by legislation. This is a great legislation. Otherwise, the Constitution loses the flexibility which is necessary to serve the needs of successive generations. It is for that reason, again, just in fact, for the recent declared for such international boxing club, that the doctrine of state is not an imprisonment of the older the standing of a decision, greater the provocation to apply the first state. A possible mistake arising out of this position was pointed out by Justice Benjamin Carter in MacPherson versus Motor Company by saying that precedents drawn from the dates of travel by stage coach do not fit the conditions of the travel allied to that possibility. Justice Randy that in the state of Washington, there is a vital act and it is not inexorable amount. The instance in which the court has disregarded the admonition are made. In fact, the full form of the principle of sterility yet not better mobility, which means to stand by decision and not to disturb what is said, was put by court in its classic English version as those things which are in so urgent ought to rest in such being the justification. It was said in James Monroe versus Frankfurt that the relevant demands of state do not be good consideration. It started an unexamined. We have already pointed out the constitution that by process of inferential reasoning, the real question may be the expression lying between the the fourth reason is the one-sided guide being harmful. That an principle rules such state reason not involved by upholding the constitution right. Like 31 that designed not only past law but future law. Supporting Article 31 of marriage on the ground is violating the constitution. The fact that the validity of the law cannot justify protection or the laws that are based on the principle of state is applied. But all the laws protected the human with those laws that but the principle cannot apply. The principle of state permits the using of law to validate and accepted or recognized over the years. It does not require a sanction that in future laws will be passed, even though they are invalid as future perpetration of the legal. No part of the law. That is only talks about state system. How the state system will control the rest so as inflexibility of the principle which has to be followed because of consistency of rule. I'm only submitting that. The once a precedent, the ratio tested with operated a precedent which is in force for number of years, fructifies into a state or transforms into a state, and the state will continue wherever there is no space for legislation. And if there is a space for legislation, if the restriction is not. Now, the other principle.
If the legislation comes in, that would be a change circumstance.
Yes.
Right, sir. So,
How departure from the precedent or a state is. I just wanted to.
there are two exceptions. One is in larger public interest. Two is by legislation which subsequently comes in. ಇಲ್ಲ ಎಲ್ಲ ಕೊಡ್ಬೇಡಿ ಬರೀ ರಿಲೆವೆಂಟ್ ಪೇಜ್ ಕೊಡಿ ಸಾಕು ನೋ ನೀಡ್ ಟು ವೇಸ್ಟ್
Paragraph 17 to 20. 93 for SCP. 441.
Roads would need trees to be cut. Trees should not be cut unless required, like in the previous matter, no, Jilla. Yes. Sarah?
17.
This is the majority. This is majority judgment.
The proposition that the provisions, the constitution must be confined only to the exploitation, which the framework with the condition and outlook of the time that are placed upon them is not acceptable and is rather rejected. Firstly, some of the current issues could not have been foreseen. Secondly, others would not have been discussed. And thirdly, still others may be left over as controversial issues, that is, term as effort issue, conflicting intent. Beyond this, it is not easier possible to disappear as to what was the factors and details behind the framework at the time of framing of the Constitution, when it is juxtaposed to the present time. The inevitable truth is that the law is not static, immutable, but ever increasingly dynamic and grows to the ongoing process. So it falls upon the superior courts in the law the responsibility of exploring the ability and potential capacity of the Constitution with a proper diagnosis, insight of a new legal concept, and making this flexible instrument serve the needs of the people of the state without sacrificing the essential basic principles of justice, like and the root of in this process, our main objective should be to make it quite understandable by stripping away the distinct and enigma that permeates and surrounds it by purely focusing on the constitutional system and speech as to make the justice more effective. Although frequent overruling of it will make the law uncertain and later decisions unpredictable, and this court would not normally like to reopen the issues which are confused. It is by now well set by line of that it is practically destroyed and the essential duty of the court to review or reconsider the earlier if so warranted and compelling circumstance, even so overrule any questionable decision, either free or not, to be carried erroneous that no decision in that necessarily from judicial review or reconsideration, fresh outlook of the constitutional legal interpretation and in the light of the principle and perception grown on this power fairly and directly fall within the blueprint of the judicial review or reconsideration. In a recent judgment, a Naga versus State of Karnataka, one of our party is following observation of the state, while emphasizing the power of this court as a recording or reviewing so on. Rectification and order does stems from the fundamental principle that justice is above all at this point of this time. Nagar case is there. Was appointed in a scheme in the state of Karnataka. The rules have been and the party of the meanwhile, the rules have been that there is a direction that all these stipendary graduates should be observed. Government said second division. So we contended, we are all graduates. So therefore, we can only be observed appointed executive post which carries degree qualification. So after the judgment, we made a mention that graduate is left out and the word graduate is added. Unfortunately, that was the day on which the unit was written. Then the government took the advantage and filed an application for reform, stating that the legitimate rights is only a second unit. Therefore, merely based on the qualification, a person cannot be appointed. I may be having a MA, it cannot be said a stipendary graduate was appointed in a scheme should be appointed as a lecturer. That was the answer. And ultimately, the order has been taken. This judgment of Nagaraj case has now approved by 9 judges and recently the Kerala and that's it. Then rectification of an order thus stems from a fundamental principle that justice is above all. It is exercised to remove the error and not for disturbing the land. When the Constitution was framed, the substantive power to rectify recall grammar this court was specifically provided by Article 137 of the Constitution. Our Constitution makers who had the practical wisdom to utilize the efficacy of such law in expressly conferred substantive power to review any judge are ordered by Article 137 of the Constitution. And Clause C of Article 148 to frame rules as conditions subject to which any judgment or order may be reviewed. In exercise of this power, the order is still proceeding analogous to order 47. The expression for any other sufficient reason in the clause had been given an expanded meaning and a degree or order passed under misrepresentation of true state of circumstances and the relatively sufficient ground to exercise. Apart from 47:1, Supreme Court would dispute at the inherent power to make such orders as or to prevent the appeal of the court. The court is thus not precluded from recalling, reviewing the service order if it is satisfied that it is necessary to for sake of justice. In the same case, do not agree with separate as stated. It is the duty of the court to rectify, revise, recall its order as when it is brought to the notice that certain of its order were passed on a wrong or mistaken assumption of that, and that implementation of those orders have serious consequences. An act of court should prejudice none. Of all these things, respecting the learned and there is none more important than here that we are born for justice. The right is always not in the spirit, but in the this the idea of the word by Madison. So he says, justice is the end of the God. It is the end of sin. Never has been, never been, until I speak but once in the sense that we declared it once, but never for many removes. Never a judge's opinion as to what last speak about does not always and under all circumstances elicit the approval of his brother, as it sometimes happen that the earlier judge might have mistaken him as lost
in the mail. Therefore, in exceptional and extraordinary circumstances or under a new set of conditions, the court is a fresh outlook and in the light of the development of innovative principles and perceptions grow along with the action applied by legal and market to reconsider the earlier role and decision, and if necessitated, even to overrule or reverse the mistaken decision by the application of the principle of retroactive impact. Otherwise, it was a wrong judicial interpretation that the constitution of law has covered. Putting the field without that wrong impact, no historic precedent, long-term practice, unorthodox. Case laws including many leading decisions in constitution bench, wherein earlier we reconsidered both are not disconnected. It would be examined for the immediate taking some serious rejected. Take construct of argument in interpretation of the Canadian Constitution. With respect to the first of these arguments, I do not think section 10 section 100 report on parliament that is declared to decide the same type of thing. They are receiving meetings. The Canadian Constitution is not law, so 194 it deals and she is capable of growing constitution can accommodate as it has many subjects and quantitative nuclear and hydroelectric, which is usually Spanish and the word can be 18th century for federal legislation. Well, there is a part that while reconsidering the decision which has already become a binding precedent or a stay decision, fraud, overlooking, public opinion, and immediate public necessity in the interest of the public are inherent mistake in the Nagaraj case, the wrong approach has been found for the separation. Therefore, the court said that there is also one more paragraph where it said a judicial review to correct the mistake, even if the judgment is faulted and wrong approach. It is open to the constitutional courts to recall to review identify. You are asking aware of 2006 416 the Kerala Forest Department, where a judgment returned up to the 136, 20 to 30 pages judgment has been upon a fraud being returned. A fresh writ petition has been filed in the Kerala. It was reopened, and it said that merely because it had been confirmed, the speaking order has been passed by the Supreme Court. This is also a reported judgment. Cannot be the basis to allow the fraud to perpetuate. Therefore, the whole order has been. So, reconsideration, recalling, and to liberalize or dilute the nature of the binding precedent or a state is entirely on a different angle. But once a case is decided and that judgment has become final, it reaches finality. That finality or a decision
can only be reviewed, can be modified in a review or an apparent otherwise impact. That is why in the natural resources, even such a power is not available to the president under Article 1. But if such power would have been.
In natural resources, it was a question of legislature overriding the judgment passed in Kaveri 1.
Yes,
In Kaveri was overruled by legislation. That is what was considered in natural resources. Whether legislation can override a judgment of the court in the advisory jurisdiction was considered. But
that is the case. If the courts were to form and are finding out and happen committed by a legislature, the legislature can remove the law and make it can pass retrospectively, even a retroactive or non-effective. That is power that is. This was created 2017-16.
Para?
I will just start from paragraph. How question is. Paragraph. The aforesaid analysis in Santosh Devi may prima facie show that the two judgment was distinguished. The observation made in Salah, but on a steady scrutiny, it becomes clear that it has really expressed a different view than what has been laid down in Salah. If we permit ourselves to say so, the different view has been expressed in a distinctive tone of the two judgment has started that it was apparently difficult to happen. Any rational observation made in para 24 in respect of self-employed or a person on a fixed salary without provision or uneducated. This is clear disagreement. And we have no education saying that we absolutely keeping in view the concept of identity. Presently, we may refer to an observation which deals with the concept of identity. In state of Bihar, an earlier decision that seems to be incorrect. We have based at a coordinate jurisdiction, considering the question later, on the ground that a possible aspect of the matter of nothing are not raised before the or more aspects should have been gone into by deciding the matter early, but it would not be a reason to say that the decision was rendered under private jurisdiction. The earlier judgment is not correct yet. We are finding effect on the later upward. Some aspect not considered and should have been done. The court has further ruled every course of saying the earlier decision was rendered for inferior not permissible, and the matter we have to resolve only including either to follow the earlier decision or refer the matter to examine the issue. In case it is that the earlier decision is not correct on merit. Purpose also this court has accepted the basis of the judgment of this court rendering so it is clearly stated that the prior constitution bench in Union of India Madras Bar Association is a binding principle. We clarified the issues that were put to rest in the earlier constitution were treated as precedent by a later constitution. In this regard, we may refer to the passage from Guises are also. The law will be bereft of all its utility if it should be thrown into a state of uncertainty by reason of conflicting decision. It is therefore desirable, in case of difference of opinion, the question should be authoritative. It sometimes happens that the earlier decision given by a bench is not brought to notice of the bench during the same. The contrary decision is given without reference to the earlier. The question has also been discussed as the correct question of the power. When two such contrary decisions are there, the practice in the Partner Court appears to be that in those cases the earlier powers are not in England, the practice is as noticed in the judgment also that the decision of the Court of Appeal is considered as a general rule to country. There are exceptions to, and one of them is thus stated in the third edition, volume 20. The court is not bound to follow execution of the court by a decision given by the individual when the court has acted in the of its own or of a court of coordinate is covered the case or that it is acted in the former case, it must decide which decision to follow. Later, it is not the it has been held by the place but the circumstance the bench is free to adopt the views according to justice and freedom after taking into consideration the two conflicting the decision is not to in short, the better course would be for the bench hearing it is the first time to decide whether it is all of one can there are no doubt that the situation arrived, the bench dealing the case, refer the so the aforesaid was articulated concept of the court. Yet this court has been followed the same as reviewed the constitution, including that of the constitution, and therefore we entirely agree with the court. Because it is a precise warrant of respecting a precedent, which is the fundamental norm of judicial. In the context, we have fruitfully known what has been stated in the the Constitution that was dealing with who get when to disagree. The decision directed to not to that's in our Constitution. In our view, discipline, judicial discipline property demand that a bench of two learning deliberation for a decision of the if a bench of two learning deliberation concludes that an earlier judgment of two learning deliberation proved very and in no circumstance the proper course for it adopted setting up the reason why it could not agree with you. In Chandra Prakash, the doctrine of binding intention to the purpose compartment in the administration of the judicial system. It promotes certainty, consistency in judicial decision. Judicial consistency promotes confidence in the system. Therefore, there is this need of consistency in enunciation of the legal principle in the decision of this. It is the whole context. This court in resolution pronouncement of law by a division this form is binding on a division same Be the remain of the judicial effort, judicial is paramount and there they coordinate with respect the judgment in front of the court went upon the issue. What would be the consequent effect of the later which have been rendered without appearance? This court noted the observation in the reviews and reproducing the passage from Indian Oil Corporation also the following impact. The division between the High Court was clearly taking the decision of this court is the number of conflict. In doing so, the division based on High Court takes something later course different. It is also not what have been expressed in the rules. We are the rule that a pronouncement of law by a division is binding on a division by the same other. And in order that such a decision be binding, it is not necessarily necessary. That is the so therefore, the decision rendered by earlier judge it also operate as a precedent. And that precedent after 10 years, it becomes a state decision. Therefore, it cannot be lightly picked, diluted, it's taken. So, in 2006, 3 SCP page 1. Decision already number of cases. It cannot be over. Paragraph 14. Paragraph this judgment of the Constitution makes that and applied recently. The High Court also after elaborated discussed the matter placed on life. In this circumstance, we do not think that there is any ruling of this body issued was taken. Further, as submitted to the senior council papers, that the reason given by the Senate council that certain aspects of not and those regarding after long or after the matter. So, in this case, the binding of a decision does not impart upon the argument, provided we find it was an argument for subsequent activity. Again, another constitution. So, this court has not upon the next session. In the same case, also negative. Certain important aspects of the meaning of the marriage was not considered present in the court at the time of the common council. We should again proceed to consider the valid rule 3 of limited. We are unable, however, to comprehend this court results on the argument presented. Final draft. Rule 3 of schedule 3 marks competently made in external past consideration. Assuming that certain then notice we see no ground on the exam. It may be pointed out that the judgment the argument of the appellate is that prior to the decision in prospect of going to the decision 19 was not in the case on and that was the reason why this court in all the previous decisions proceeded on the examination whether there was infringement or not. And we are unable to find that there is much substance in this. Case and other issues that follow it, mainly based on examination, interrelation, 1 act and 31. There is no question of the third issue. Guarantee never done. Is apparently too late now. In the connection, we may refer to the observation of the score in accordingly, even if certain aspects of the question were not properly, we would decline to answer upon the exam question. The decision as following none of the decisions the argument are not conducted. Law may be protected under article. But people will still over the challenge. And they remind us that the decision of the court is reminded the contention under the binding effect of the decision does not depend upon whether the argument is to find the subsequent activity. The benefit of not serious case. Merely because the aspect now presented as the vanity was not expressly considered by the given there are not taken pending effect of here the area set is clearly in paragraph 30. Go down to take it out from the umbrella employment standing chart. One word 48C. There is 45C, one more notification. Both the notifications that was sent to be handed in the full. But in the division bench, it has been held that when 45C notification was issued, the government had it in mind the provisions of the Employment Standing Act. Therefore, the deemed application of fine has to be presumed and discuss the one notification. And two notifications will serve this purpose. But this was the argument for
But
no
then,
advanced by Ramamohan that is there.
when they do the full bench, AVR Shetty said there's no requirement of two notifications. That is under KSRTC C&D. The full bench, while considering a cooperative societies act matter, came to a conclusion that there are two separate notifications which are required. Then the division bench, considering a RTC matter, declared the law that because of stare decisis, this would apply, it would continue. But the contention still of Mr.
No. Whether AVR Shetty's case, effect of AVR Shetty in the wake of full bench judgment. Again, there is one more judgment. One more judgment. I think the principle should be, it continues to be a state principle. So far the AVR Shetty's case. And it binds on the party. Otherwise, when the third decision is not in there. It is open for them, it is open for the court constitutional court, subject to the constitution.
Again, what we told was that there is, since the third decision is of a division bench, a single bench we are bound by. We cannot differ from it, except in one decision that you have now cited as a departure for it. Even a bench of a lower quantum can differ from a higher bench and then refer to a larger bench.
So the very same question crop up later. Whether KVR Shetty is still to be revisited in the wake of the full bench. Now the law is later.
By the division bench.
By that. Therefore, the question would stop there.
Insofar as we are considering a
The
single
power-
bench,
The power of the court, constitutional court, to revisit that issue, to reconsider that issue, has been only
the submission of Mr. Datta is that the division bench could not have virtually overridden the full bench is what he's saying. But insofar as we are concerned, since we are a single bench, we are by the division bench. You can argue.
I'll make it next time.
No, that is why the other two angles. If the second occasion and third occasion, if the DB has already said, no, in view of the full bench judgment, the regulation is still have a force. And this is not the case where the regulation was notified, was not acted upon. That is on a different footing where it's a dead letter. That is not the case. Regulations
We knock it upon day in and day out, so that's
Yes.
not the issue.
The regulations are still in operation. And the regulations are enforceable, only on all, not one or two. So therefore, such a question also cannot be raised at this belated stage for the simple reason that any decision rendered by the constitutional, if it is followed in other cases, consistently, over a decade, it becomes a more effective, stronger, the edifice of state decisions. And the state decisions are the law instead are not weakened in the other subjects. First is a local legislation which has been interpreted, which has been followed subsequently in number of cases and acted upon by both the parties. And various transactions have been taken. The question of revisiting is overruling it is not stems from a statute or a constitution. It's a constitutional power, inherent power. The inherent power has been already exercised. And there is a consistency. Consistency is the rule of law, which is the basis on the jurisdiction is. Therefore, I only submit the second word with my amendment as clause not okay. A law which is clarified based on KVR Shetty's case and the pulpit and laid down that these regulations are still in force has been followed in number of and it's a local legislation.
There's a earlier stare decisis prior to the declaration by the division bench. Subsequent declaration by the division bench, you are saying there's another stare decisis chain of events which has occurred. So both the stare decisis chain of events would have to be applied as.
I'm just I'm not going to this is the principle. A decision which is in force applied in number of places, interpreting the local legislation of a particular state. It continues to operate as a state decision. And the doctrine of state decisions debarred the court from revisiting articles. But the broader principles of reconsideration is set out in para 17 to 22 of Supreme Court article. So therefore, that this is not a case where the wrong affidavit has been. This is not a case where a fraud has been or misrepresentation. This is a case where the effect of the rules are still in force and declared by the court, not one time, second time, third time, fourth time, unfollowed number of times.
It was only declared once and followed many number of times.
Yes. In fact, that is how I will just say. 6 years. That will be good.
Para?
Para 22. That is how the distinction between the res judicata and the peace. And then with the next question.
Judicata is inter partes.
So, res judicata means a decision rendered between the parties. A decision by inter parties. If when it comes to the ratio density, it binds on others also. But precedent means precedent applies to future cases, to all, irrespective of person is a party. That's a distinction. Paragraph 22. A decision can be set aside in the same day and a prayer for review of as we have said, overruling of a decision takes place in a subsequent place where the precedential value of a decision is not in question. No one can dispute that in particular judicial system, it is open to a court of superior jurisdiction or strength before which a decision is bent of a lower strength is taken and an authority to overrule. This overruling does not operate to upset the binding nature of a decision of the party. To an earlier list in that place, for whom the principle of the judicata will continue to operate. But in that case, what the principle is being proceeded, that
overruling would take place in some other case. Not in a case where a question of law laid down in A is being considered in B. Overruling take place in B, the principle. So therefore, overruling is not take place in A because overruling of A decision is permissible only by a review or an appellate.
Yes.
Or a witness. That is all.
Intra parties in that matter.
Yes.
The KVR Shetty intra parties, whatever was laid down continues to be binding on the parties to KVR Shetty. But once the law was laid down in Pandavpura, post that, that law would have to be made applicable. However, we were in view of declaration in the 1996 matter by the division bench, a declaration that Pandavpura will not apply to the 1961 regulations. Subsequent thereto, 61 regulations have been made applicable.
And there is a clear declaration of law that KSR is a regulation in a statute. That is the third of it. After that.
Contention is that not this. His contention is very simple. That is why we asked Madam to say this. His contention is that the division bench could not have done that. Now their cause of action has arisen now. They had no opportunity to challenge that.
Would not have been done it was the argument. But
So-
such an argument is a fallacious, it cannot be attended because of 1, 2, 3.
So what they are saying is, what will be binding on us is the full bench and not the division bench as currently.
Yes.
Is what the contention is. It's a very simple but very complicated argument which Mr. Datar is addressing.
Argument is advanced. Still you are circumscribed by many other factors.
And we are faced with both the full bench and the division bench order.
And that we are also faced.
But this argument has already been addressed by the division bench.
Yes. And this question is resolved by the another division. And again, the division bench is being followed in number of ways. So at this distance of time, is it possible? Can you go on agitating the issue?
It can only happen by the division bench, not by us. Is your submission. What else? You want to submit today or you want to go through them? You want some more?
In all cases, this question.
Don't. But yeah, when do you want to do it?
You got a very good opportunity here to develop.
But our mat will argue on Niman Kaspan. Opportunity our get. 10 madam. So when do you want? Next Friday.
On Monday.
Monday andre 4th,
6, 7, 8.
6th is holiday. So when
7, 8 or something like that. 4th.
Sixth is holiday. Holiday. Seven. Third. We recommend our senior counsel on the aspect of the applicability of the decision of Pandavpura case. Relist for further arguments on 8 September at 2:30 p.m.
Which
They don't have it.
no, if they don't have negative record,
Okay, report.
Certainly, 13B is recorded in all judgments, not only here. It's been recorded in all the earlier judgments.
Be produced, they have not been verification time. So let it be on record.
We have not directed them to produce.
So the losses are raising because we are not raised in our petitions.
It's raised in the petition. That is why we had to ask for it.
We have, of course, we have said.
You raised it. And it was raised in that other matter. That's why
Other matter.
we got it to your notice. You also raised it in your petition. When we were dictating, we saw that it's been raised in your petition.
Now, the entire premise of KVS was, there was no notification of that. But except that, then they said, one.
All these submissions, everything, we have already dictated. We have started with the reasoning. That is, no, not then. When we are dictating the reasons, that is when we saw that you had raised this issue here also.
And
Is a separate one. On each, we'll take it up.
take it, please.
Respond number? Bandari is here.
I have appeared for responding to your lordship.
Yes. Hmm.
The water was flooded into the property of the pit, which caused the destroy of the wastewater flooded into the petitioner's property, and petitioner's land filled with the wastewater and mud. Because of this, the agricultural land of the petitioner got completely damaged, and the standing crops were being destroyed. For the same, the petitioners have given several representations to the respondents seeking compensation for the loss suffered by them. So they haven't considered
Mr. Bandari, have you constructed a wall so that this doesn't happen in future?
No, I'll submit your lordship. Water Urban Development Authority or Water Urban Development Authority has constructed the pumps and they have given to the corporation for maintenance. With the vented dam and pump house, it was constructed by the Urban Water Development Authority.
Yes.
We are only maintaining the pump house and we are maintaining the dam now. For the supply of the water to the Mangalore city.
Yes.
Now what is his contention is, your lordship, because of the water plunges into his property, that erosion has been taken place, and this river comes under the minor irrigation department. Either he has to approach the minor irrigation department or the local judicial authority of the panchayat for the grievance which we have sought, your lordship, because river is coming under the minor irrigation department now.
This is not from the river, this is from the canal. And in the canal, you are discharging water.
As I have given the understanding in the morning, your lordship, it is a river erosion, your lordship. Some tributary was there. Tributaries to the river. ಅಲ್ಲಿಂದ ನೀರು ಬರ್ತಾ ಇದೆ, ಅಲ್ಲಿಂದ erosion ಆಗ್ತಾ ಇದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
So ನಿಮ್ ಪ್ರಕಾರ minor irrigation department ಬೇಕಾ?
ಅವ್ರು ಮಾಡ್ಬೇಕು ಅದನ್ನ. ನಮ್ಗೆ ಅರ್ಬನ್ ವಾಟರ್ ಸಪ್ಲೈ ಅವರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ ಮೇಂಟೆನೆನ್ಸ್ ಮಾತ್ರ ಕೊಟ್ಟಿರ್ತಾರೆ.
AGA is ready to take notice, no problem.
ಅವರನ್ನು ಪಾರ್ಟಿ ಮಾಡ್ಲಿ, ಇರಿಗೇಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರು ಪಾರ್ಟಿ ಮಾಡ್ಲಿ.
ಏನಾಗಲ್ಲ, let us find out who is to solve this.
ಅಷ್ಟೇ. ಅವ್ರಿಗೆ ಏನಾದ್ರು ಅಲ್ಟಿಮೇಟ್ಲಿ ಸಾಲ್ವ್ ಆಗ್ಬೇಕು ಪ್ರಾಬ್ಲಮ್ ಅಷ್ಟೇ.
And more than the damage, it is that wall has to be built so that it doesn't repeat again. Who is going to build that will be the issue.
Yes, that's the issue.
Not that it should not repeat. Shri Harish Bandari, learned counsel for respond number 3, submit that the respond number 3 is only maintaining the water treatment plant and attached to the dam. And the cost for the petitioner is water inflow from the river, and as such, it would be the minor irrigation department who would have to answer the grievance of the petitioner. In that view of the matter, the state of Karnataka, represented by the Secretary, Minor Irrigation Department, has got on record as respond number 7. That AG accepts notice for respond number 7. Counsel for the petitioner to carry out necessary amendment and file amended cost item, and thereafter furnish 2 sets of the petition along with annexures on the learned AGA. Learned AGA seeks for and is granted 10 days time to obtain instruction as to whether the canal in question is under the maintenance of the minor irrigation department. If so, what are the precautionary steps that the minor irrigation department would take so that this kind of an incident does not occur in future? Released on 15th September. Petition put with amendment amendment.
25. Yes.
You are appearing for respond number 6, Mr. Andhra. This was also directed to 4603 is already disposed. Okay.
Yes.
Why was 4603 connected?
Because my lord has directed that we put it along with this.
Some of you have said it's connected, so that's why we connect.
They also.
But then no, dispose agidare state any part.
There is a connection.
And that 4603 appears to be GMCPC.
Yes.
They said respond number 6 has filed a suit for exemption. And stating that there is, they said government land is a Kumki land attached to his land, therefore he sought the injunction against the government. The road which the villages are concerned goes to the same road, land, where the honorable courts by disposing of the petition have stated that the villages have they should not disturb the villages' right to use the road going into the same government land. Now, the difficulty is we have no issue or reference with respect to respond number 6. Larger issue with respect to the land or whatever right there, etc. We are only concerned with the small portion of road that passes to the government road, or which travels from Karnataka village to Nikibai, where all the petitioners reside. In fact, I have a sketch that
And the which jurisdiction does this road come under?
in this respond number 4 jurisdiction is there on the road.
You are appealing for this. So is there a public road situated?
Any order from the government under section 79(2) of the Karnataka Land Revenue Act. But then instead of getting an order from the deputy to come for the privilege, as per the land, use of land, then for the land. They file a single suit by the link. They threat in the land court and the custom. And these are the disclosure of the order to make it clear. In spite of this order, they are upset. That is so where the petitioners
The road exists.
road exists,
Only usage is present. Where is the where are the photographs of the road?
Thank you, Lordship. Yeah,
And also show how we have created blocks. You just cut the trees and all that. Now villages are created. But once you accept the villages,
So you should take action. You should take action against him.
Page 29 of
Who cannot reach that? You are the panchayat. You should take action if they is doing something like that.
photos, page 29.
Statement of objects. They have filed an application at
Page 29.
Just a moment. One of
Up from road, page 29. Concrete road, page 29.
and it stops at the property of the.
The disputed, that is where now the dispute is.
So there's a mud road there,
Please.
and you have not formed a road there. Why you have not formed a road?
We are ready to follow, but in spite of this order, he is blocking, he is not allowing panchayat to.
If somebody blocks, the panchayat won't do any work.
The suit is pending. But that is how what it is.
Suit is filed for? This is Kumki land. And rights are under land.
Your worship, now kindly see annexed R4 to the statement of objects.
Yes.
R4 at page 45.
Page?
Page 45. Page 45. That is the petition filed by the respondents 5 and 6
Yes.
before this on the report. Kindly see paragraph. Order. This petition filed by the plaintiff is directed against the given order. It is 13/2021, OS number 26/2020. On the file of report to the second MA number 01/2021. I order it in by the application for temporary use filed by the petitioner was rejected. Application to locate the order of temporary use was announced and confirmed by the first appeal court. Further, learning process of petitioner and
I think there is a order of status quo in all respects.
But there's a clarification of the next
on
page.
this petitioner giving to the villager by this petition, and it is not a.
You have to move an application before the same court.
The trial court should dispose without influencing the findings, observations in the appeal order. It also made clear that this order shall not entitle enable either of the parties to obstruct or hinder any right of way. If any available in the suicidal property in favor of the parties, should ensure that no law or problems created by them. So therefore, the honorable court has given a direction that if there is any way, that order will not come into the right of the way, usage of way. All that we are stating is, we are not interested with his rights or privileges that he wants to seek on the larger extent of the government land. All that we are concerned is the small extent of road which passes to the same road which has been used time in order by the local petitioner,
You cannot prevent them from using it.
It is not a public road. It is.
Pending the disposal of the suit.
Yes. Yes.
Pending the disposal of the suit, the status quo has to be made.
Yes.
But you shall not
Yes.
interfere with or obstruct
Yes.
any right of way of any person.
Yes.
So you can't prevent them from using it.
These petitioners who say that they have an interest, is public interest. First of all of them come.
That is determined in the suit.
Yes, sir.
But until the determination, you can't stop them from using it. That's what the order says.
This is not, they are not using the road.
There is already an order. We have taken the order already. Everybody taken the order.
Respondent number 4 was heard. Respondent number 4 was heard.
Please understand this. There is an order of status quo. The trial court has been directed to dispose of the matter.
Yes.
But you have been directed not to hinder, obstruct anybody using the road.
If obstruct or hinder any right of way, if any available.
If any available and the road is there.
Road is there. Report, let me see the court transcript.
That day, that is my respondent number 4 has made an
Do one thing, ask for a clarification before the same.
application.
You ask for a clarification.
They have sought for clarification because the honorable court when issued notice to the respondent wanted to know whether they form the road or not. Therefore, they sought for a clarification. While they use the road, can we form the road as well?
So what happened to
That
clarification?
clarification lordship is sitting in Karnataka, being therefore the matter would not.
No,
So
you-
therefore, the question.
We'll also observe this because see, we can't interpret an order passed by a court.
Definitely not. All that is stating is.
You will be saying something, they'll be saying, it won't read. Let the same judge, let the same judge clarify what he meant
If they
by
say
it.
there's no road, all that is there.
Mithun, can we say anything on an order which has already been passed by a coordinate bench?
But then they.
On that order, can we make any comment?
They've accepted.
We are not
the order.
sitting on appeal on that.
They've accepted the order.
You have moved a clarification application. Mention it and get it listed. Doesn't matter where we are sitting, we always take it.
But what I'm saying is that they have finally to ascertain whether they can form the road as well as they use.
So you move another application for use there.
But they have accepted the fact that there is a, because they have not objected the order when they take.
Kariga is denying, if any.
Lordship,
And if any entity there.
It's a matter of fact to ascertain. Let the respondent would carry out the survey, give a report because Tahsildar has given a report.
Why don't you ask for clarification, close the matter?
Just all that we're saying is if respondent would carry out the survey and gives a report. That will, because that is only with respect to, if they say there is no road,
You're asking for a mandamus to clear the obstruction.
please, and they say there is no road.
In light of that order, can it be cleared?
Only with respect to road.
Only with respect to road also, in light of that order, can we direct this?
Because the honorable court has stated that if there is road, please do not obstruct.
Then we will have to dismiss this.
All
We will
that
dismiss this, reserving liberty, that's all.
all that I'm stating is, if there is road or not, is a matter of, subject matter of fact, if that can be.
Can we issue a mandamus for that? Can we issue a mandamus for that, Mr. Mittal? Civil suit which is pending.
There is
Then we issue a mandamus.
government land.
Already approved. Please understand the situation. There's already an order passed by a coordinate bench. You are asking us to interpret that order. Sitting in a writ petition, it's not possible.
1 second you get statement respond.
Yes.
Line.
Next line over there. Next line over there. Please read the next line.
Further contention that assessing the property to the property. Means if they are making this statement, they will not obstruct or they are
No,
not
no.
obstructing. Then that time only.
They are not even accessing where the question of obstruction is what they are saying.
They can't claim with the right over the road. That is the problem. Can you see section 79 40?
Can we decide that when the coordinate bench has already passed an order? Please understand the basic principles of law. We do not expect this kind of submission from you, Mr. Counsel. Can we decide that when it's already decided? Can we reopen it when it is already decided?
That will be better than the I'm not telling you the issue.
That's why you go seek for clarification. There's an order passed.
What section 79
So, petitioner is before this court seeking for the following reliefs. The contention of the petitioner is that there are villages and residents of Karkada village, Umati Bailu, Karkada, Saligrama Post, Brahmavara Taluk, Udupi district.
Because the lordship, if I make a submission.
Petitioner is You were given an opportunity, you did not do it.
That's one number four. May make a submission. Now, the matter is pending in the trial court. Now, just for the matter of sake of submission, if I would go back to honorable court, they would say, make the same submission that they would deny the road. They would deny the existence of the road. So,
We cannot issue
I
a
can-
mandamus when issues are in dispute.
I understand that. I
You have no
understand.
vested right.
I understand that. But the fact of matter of fact is, since the application is pending, may the lordship give me each time, every time.
That is exactly what we told you in the first this one.
No, I
We don't
understand,
want
but
to
the only point is, since they're denying the very existence of the
We will
road,
dispose this matter with that clarification. Various
this
times,
matter can be pending if the
Not
honorable court gives a suitable direction, then the lordships may pursue
not
this matter.
necessarily, not necessarily. On the ground that
But
the
again,
petitioners had access,
precipitating this matter again, not in the suitable direction. I may request the lordships to,
so if that court clarifies it, that will inure to your benefit.
please, sir.
Use that, we can't issue this.
Please, sir, but the point is, every time they go to survey, the tahsildar is giving a report, the respondent will go carries out obstruction and interference. Therefore, we have sought for direction of this honorable court for
We
carrying out,
can't issue this when the matter is seized there. Please,
subject to what the clarification.
Mr. Mittal, you have addressed your argument, let us dictate our order.
No, what I'm saying is, if the lordship.
This is not a negotiation. You have addressed your arguments, we will be.
I'm only stating the lordships may, attend the matter, okay, I'll just see if any clarification is available there. Subject to that, the lordships may pass appropriate orders.
Whatever clarification is given will inure to all your benefit.
But
If
since
the
there is-
clarification is permitting you to use, we'll permit you to use. There's no further direction to be issued by this court.
Further direction is for formation of road also. I've
That-
sought for further direction.
That will be subject to the two, which also the only clarification,
Give the direction.
only clarification that you can seek there is whether you are permitted to use it or not.
But if the
All
lordship,
others has to be decided in the suit.
please, but if the lordships directs that if there's a road and if the survey has to be carried out in accordance with law, the same can be carried out, then the lordship, this repetition will be important and
That
pertinent.
direction itself will be binding. Why do you need another?
Because that is very limited to the fact of its injunction, so I will not be able to carry out a survey in that particular matter. Because a suit for injunction, a 26-rule-9 will not be maintainable before the trial court. Therefore, for carrying out survey, I will have to indulge in this in this court, this
They are
repetition.
party to that suit.
Lordship, their party, I'm not party, your lordship. I'm not party. Therefore, this repetition is very important.
There are other players also.
That is what we told you first thing. You wanted to argue, we heard you, now you don't want us to pass orders. Not fair. Not fair, Mr. Counsel. Doesn't mean you will argue, and if the order is going against you, then you make the submission. You should not be doing this. At the request of the counsel for the petitioner and respond number 4, we list on 26th September. Yes. Respond number 4 is filed a caveat. Respond number 4 is a private party. Why did you Shankar? Caveat hakilara. It's a pending matter. How can you move a pending matter for end of the list? Mr. Counsel, the list cannot come in the morning. How will they know that the list has come if you move like this? It is a pending matter, you can't move end of the list. It will have to come the next day.
And there is a partnership.
We'll remove the road if it is formed, but you can't move like this. You'll have to come on Monday. Release on Monday. Pending matters don't move end of the list. ನೀವು ಅರ್ಜೆನ್ಸಿ ಅಂತ ಹೇಳ್ತೀರಾ ನಾವು ತಗೊಂತೀವಿ ಕೇಳಿದ್ವಿ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರ ಅಂತ ನೀವು ಹೇಳಲ್ಲ.
Serial number 48. Tuition करके.
The Shiv Shankar. Sorry, the order dated 23/8/23, none appears for the petition today also. It appears no steps have been taken to bring the legal version of deceased respond number 4 on the bed. It appears nor have objections been filed as regards other applications which are pending. It appears that the petitioner is not interested in prosecuting the matter. The petition stands dismissed for non-prosecution. Pending IS stand dismissed. Petitioner hoita.
49. Hearing Assemble and corrected matter.
Jaglur Town Municipality. Mahesh R. Uppin is directed to accept notice for respond number 4. Counsel for the petitioner served 2 sets of the petition along with the annexure and said counsel. We list on 25th September. At the request of counsel for the petitioner, we list on 29th September. Interim order earlier granted and extended till next stage. Petitioner is before this court seeking for the following. List is covered under so and so. Any amount in deposit? So there's nothing. Para 6 level. No para 6. Yes. A 152-1 or no, we have passed 2 orders as well. 152-1 or tax.
152-1.
Same. Any amount in deposit?
25%.
Para 6 adjusted as the interim order. Any amount paid by the petitioner to be adjusted towards any future tax dues of the petitioner. Para 6. 56. Any amount in deposit?
25%.
Pursuant to interim order.
Pursuant to interim.
Again, para 6 as it is. As it is.
Wait.
Sandesh. Mandamus, concerned, allow it or reject it. Consider the representation. If there are no grounds for making the payment, you reject it. In a tertiary, you already rejected. So arbitration area. The ADR ಏನಿದೆ? Any ADR? You have passed an order on 1/4/22. None appears for the petitioner. Released on 11th September.
Here number 59. There is one more table.
Which one? Yes.
The statement in matter of the fiction number as a purchase of the site. Measuring over 1,190 square feet million in the year 2020 million. The respondent number 4 has no right in this property million. She has given a complaint to the Municipal Police million. Thereafter million the BBP has mistakenly entered the Tata million. Instead of mentioning the survey number 133/1, stating that million assessment number 133/1. And also the measurement and
Survey number 133/1 and assessment 133/1. Hmm.
That basis data was registered earlier to the petition. And it's a alternative.
Yeah, we'll come to that. But is the assessment number 133/1 and survey number 133/1 the same? They must be different.
There is a rectification. My last one.
One ನಿಮಿಷ ಇರ್ಲಿ.
Rectification deed has been.
Only the other. In the rectification is shown as assessment number.
Yes. Selection.
Let him clarify, we'll come back to you. ಯಾರು ನಾವು ಎಲ್ಲೂ ಹೋಗ್ತಾ ಇಲ್ಲ, ಇಲ್ಲೇ ಇದೀವಿ. ನಿಮ್ಗೇನಾದ್ರು ಅರ್ಜೆಂಟಾ? Where's the rectification?
Election J page number 45.
ತಿದ್ದುಪಡಿ. Assessment number 133/1 ಮಾಡಿದ್ದಾರೆ. Now what have you done? You entered both their names.
What was funded? The last there is an election H Millardo. On the basis of Bill Millardo, he had executed a gift deed in favor of assessment number 4 Millardo. In the Bill Millardo, the survey number 133/1 was shown Millardo. With along with schedule Millardo, ಬೇರೆಯವರ ಪೂರ್ವಕ್ಕೆ ಬೇರೆಯವರ ಜಮೀನು ಪಶ್ಚಿಮಕ್ಕೆ ಉಳಿಕೆ ಜಮೀನು.
What is the name of the original owner? Whom did you purchase from? ನಿಮ್ಮ same did any?
Petitioner has purchased from original owner Millardo.
Yes, the original owner is complete misnomer. Original could be anybody. Your previous owner.
Previous owner.
ಯಾರು ನಿಮ್ಮ previous owner?
ಮರಿಯಪ್ಪನವರ ಮಕ್ಕಳಾದ ಸುಮಾರು 20 ವರ್ಷದ ಪುಟ್ಟಯ್ಯ, ಅಶ್ವಥ್, ಜಗನ್ನಾಥ್, ರಾಜಣ್ಣ ಮತ್ತು ನಾರಾಯಣ. The children from the children of Mariyappa, they are purchased. After execution of the agreement, Millardo, when they came to know Millardo, thereafter they made a rectification deed in favor of Tata Millardo. ಚೆಕ್ ಬಂದಿ ಬೇರೆ ಇದೆ.
ರಾಜಣ್ಣ, ನಾರಾಯಣ, ರಾಮಣ್ಣ.
Ramana is the father of
Ramana son of
fourth respondent.
Ramana son of whose son is he?
Narsimha.
Ramana son of Narsimha.
Narsimha. He is out of family of my Millardo.
Part of that family at all. Before change, were you given any notice?
No, madam. Any notice has been given. Melody, yesterday my first time as well.
Then you will have to file a revision, madam.
There is no order, Melody. This is endorsement.
There's no kata was there in your name.
But we have given.
One ನಿಮಿಷ ಕೇಳ್ಬಿಡಿ. ಯಾಕೆ ಅಷ್ಟು ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ ಇದೆ? ಎಲ್ಲೂ ಹೋಗಬೇಕಾಗಿಲ್ಲ. There is never a kata in your name. Respondent number 4 applied for the kata and got her name registered. Right or wrong, it is registered because she is the only applicant for the property. So what do you have to do? There is a review which is available, where you will have to place your documents and before the court.
Given application before the immediate to interview kata in my favor.
When did you give that? That already everything. Reviewer. You'll have to place all the, you cannot deal with those things here. You file an application. Correct. Because there's already a kata entry made in favor of respondent number 4. Revenue officer cannot consider it. You file a review, place all your documents to review this order. That's the correct way to do it. The petitioner is before this court seeking for the following reliefs. The petitioner claims to be the owner of the land covered in the assessment number 133/1, form in survey number 46 of Bollara T, Vishwavati Nagara, Thane Goronalli, Dakle, Kamakshi Palya, Yeshwantpura Houli, Bangalore North Taluk. The fourth respondent apparently had filed an application for registration of kata in her name by producing a will and a gift deed, as also a rectification deed, on which basis the kata has been entered in favor of the respondent number 4. And it is on that ground that the application made by the petitioner for issuance of kata in her name has been rejected by respondent number 3. And it's in that background that the petitioner is before this court seeking for the approval. It's a matter of fact, it's not in dispute that there's no kata ever entered into in the name of the petitioner. And the only kata which has been entered into is in the name of respondent number 4.
Standing in the name of the petition.
Though there may be several other documents in favor of the petitioner. If that be the case, it would be for the petitioner to approach the to file a necessary review application under section 150 of the BBMP Act 2020, seeking for review of the entry of the name of respondent number 4 in respect of the said property by placing on record necessary documents. The present reliefs would not be maintained. I said reserving liberty to the petitioner to file necessary review petition as opposite the petition stands disposed.
On the basis of illegal documents, you
are wasting your time here. In the meanwhile, respondent number 4 is restrained from alienating the property. Alienating the property, alienating, dealing with, or encumbering the property in any manner whatsoever. I'll get 2 weeks. 22 matter. Yes, Raju seeks for and is granted 2 weeks time to file his Vakaratnama and statement of objections. If objections are not filed by 29th, the same would be taken as not filed. We list on 5th October. ಎಲ್ಲ ಒಂದೇ ಟೈಮ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ. The SB early.
AP for respondent.
None appears for the petitioner. Released on 4th October. Hmm. In have you issued the notice to him? ಬಂದಿದೆಯಾ ನಿಮ್ಮ notice? Consider this a notice, you supply those documents. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? We are only asking for amendments. We can direct them to consider your application. They are saying that they have seen your application, there's shortfall in documents. Please supply the document, then they'll consider. Supply that.
And the notice may be.
Notice. Other copy covered. Other copy. Petitioner is before this court taking for the following reasons. The contention of the petitioner is the petitioner is the owner of property covered under survey number 1, block number 22 and 23, now known as Nandini Layout. Survey number 1, Nandini Layout.
How is this called as Nandini?
ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? 1,76,000 square feet ಅಂತ ಹಾಕಿದ್ದೀರಾ? Was the Khata in your name? Never. How did you purchase it? ಎಲ್ಲ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಆಗಿ ಆಯ್ತು, ಲೇಔಟ್ ಫಾರ್ಮ್ ಆಗಿತ್ತು, ಎಲ್ಲ ಆಯ್ತು. ನಿಮ್ಗೆ ಇವಾಗ ಎಲ್ಲಿ ಬರುತ್ತದೆ? The petitioner, survey number 1, so and so. The petitioner claims that the father of the husband of the petitioner was granted the land and a darkhast, towards which the petitioner's husband succeeded. And on the expiry of her husband, she has succeeded to the property. And as such, she had made an application for issuance of Khata, which has not been considered by the respondent, despite necessary documents having been submitted. The counsel for the respondent submits that on consideration of the application, the respondent had issued a notice dated 15/12/22, calling upon the petitioner to furnish certain documents which have not been furnished. If the same is furnished, the respondent would consider the said application strictly in accordance with law after ascertaining the rights of the petitioner, if any, in the property. After examining if the property exists as such as on today. In that view of the matter, I pass the following order. The petition is allowed. A mandamus is issued directing the respondent to consider the application filed by the petitioner and the representation dated 16/12/2022 at Annexure A within a period of 60 days from the date on which the petitioner furnishes the documents in list thereof has been handed over to the petitioner today.
My lord, I am appealing for the petitioner in this matter. My lord, this is a matter with regard to the my lord, wherein the construction has been made without license. So we had given a complaint, my lord.
Has any inspection been ordered? You are appearing for whom, Mr. Sudhakar? Huh? Subsequent, Michael earlier, how you cares?
There was an order passed in MFA where the petitioner and myself were directed to maintain status quo with respect to the property. And not with objection, I filed an order passed in.
Mr. Shetty, there is an order passed in MFA.
The order with regard to MFA is to, my lord, the continue with the suit, and with regard to the status of the property, status quo was directed to be maintained. But this is altogether a different aspect wherein, my lord, that is with regard to the title of the property.
It's further directed construction put up by a respondent dependent to be subject to final outcome.
But violation of the conditions, my lord, with regard to the license and other aspects, that has to be taken care by the BBMP, my lord.
There is a finding here that will be subject to that.
That is true, my
Coordinate
lord.
bench has passed an order. We are not sitting on appeal on that. If you want a clarification, you ask there. We can't, when there is this kind of an order, we can't interfere.
Please, ma'am.
So we'll dispose of the matter subject to the result of the suit
Please.
or
Very
any
well.
clarification in MFA.
Please, very well, ma'am.
Petitioner is before this court seeking for the following rules. The contention of the petitioner is that the respondent has put up construction on his property illegally in an unauthorized manner. As regards with, though complaints have been submitted, the respondent, the statutory authority, namely the BBMP, respondent number 1, has not taken any action. The counsel for the petitioner submits that there is a civil dispute pending between the petitioner and respondent number 2.
True, ma'am.
And while order dated 14 March 2023 in MFA number 1006 of 2023, a coordinate bench of this court has directed that the construction put up would be subject to final outcome of the suit, and that the respondent shall not claim, respondent number 2 herein shall not claim any equity in that regard. In that view of the matter, when all the issues, you suit for anything?
Suit for declaration. Injunction, madam.
What is the declaration that?
That we are the owner of the property. My lord, during the subsistence of our sale deed.
There is an ownership dispute. That is
Ownership dispute. Yes, ma'am.
In view of the fact that there is a suit which is pending in OS number 7083 of 2022 on the file of the 7th additional city civil and session judge, wherein there is a dispute as regards the ownership of the property subject matter of the present petition. I have the considered opinion that the same would have to be adjudicated in the said suit in terms of the order passed by a coordinate bench of this court in MFA number 1006 of 2023. As such, I pass the following order. The petition is disposed. Liberty is reserved to the petitioner to approach the competent authority upon the suit being disposed. Suit and so on.
Published.
Chandrasekhar.
But I represent the petitioner, please, Lord. Lord, I represent the petitioner, Lord. It's a mandamus, Lord. I have made a representation at annexure D3, Lord, to correct the measurement in e-katas, please, Lord.
Petitioner is before this court seeking for the following reliefs. The condition of the petitioner is that the petitioner is the sole and absolute owner in lawful possession of residential sites number 1 to 4, 7 to 14, and 7 to 24, formed in survey number 28/1, 3, 4, 5, and 6 of Hattiganaldi village, Anneshwara Gram Panchayat, Devnalli Taluk, Bangalore Rural District. E-katas, on application being filed by the petitioner, e-katas were issued. However, there were certain errors noticed in the said application on the measurement. As such, the petitioner made a fresh application for correction of the measurements on 22/10/2022 on annexure D series. They said representation not being considered and no order being passed thereon, the petitioner is before this court seeking for the office of relief. Whenever any application is submitted, application stroke representation is submitted, it is required for the statutory authority to consider the said representation and accept the same or reject the same in accordance with law within a reasonable period of time by passing a reasoned order. The same not having been done for over a year now. And the considered opinion that the petition would have to be allowed. As such, I pass the following one. Petition is allowed, a mandamus is issued directing respondent number 4 and 5 to consider the representation of the petitioner dated so and so at annex 22/10/22 at annexure D series within a period of 30 days from the date of receipt of a copy of this order in terms of Sakala so and so.
Grateful to me.
ಹುಡ್ಕೊಳ್ಳಿ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರೇನೋ ಕಳೆದಾಕಿದಾರೆ.
I'll furnish me.
Petitioner to furnish one more copy of his representation to the respondent. The period of 30 days will be calculated from the date on which the copy of the representation is furnished.
Please, my lord.
None appears released on 4th October. Mr. Bandari.
Last time
5:30 ibru ibre ತಗೊಂತೀವಿ ibru ಇಲ್ಲ. They are entitled not to be here after 4:45. ಅವ್ರು ಇಲ್ಲೇ ಇರೋ ಏನ್ ಕೊಡಕ್ಕಾಗ ಅಷ್ಟೇ. Not in their absence. We'll have it on Monday, Mr. Rajesh. Actually, ಅದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಮಾಡಕ್ ಮುಂಚೆ ಅಲ್ವ. List on 4th September. On 4th, under the caption consideration of interim application.
ಇವತ್ತು ಒಂದು ವಾರದಿಂದ ಆಗ್ತಾನೆ ಇಲ್ಲ. ಒಂದು ಮಿನಿಟ್ ಅಂತ ಹೇಳಿ ಅಂದ್ರೆ ಅವರು ರೀಫಂಡ್ ದುಡ್ಡು ಕಟ್ಬಿಟ್ಟಿದ್ರೆ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಾಗ ದುಡ್ಡು ಕಟ್ಟಿದ್ರೆ ಏನು ಕಷ್ಟ. ಎಂಟ್ರಿ ಮಾಡಿದಾಗ ಏನಾದ್ರು ದುಡ್ಡು ಕಟ್ಟಿದ್ರೆ ಅರ್ಧ ರೀಫಂಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯೋ ಇನ್ನೊಂದು ರೀಫಂಡ್ ಅನ್ನೋ ಪ್ರಶ್ನೆಗಳು ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಆಗಿದೆ ನೋಡಿ. ಒಂದು ವಾರದಿಂದ ಆಗ್ತಾನೆ ಇದೆ. ಎಲ್ರಿಗೂ ಆಗಿದೆ, ನಿಮ್ಗೂ ಆಗಿದೆ. ನೆನ್ನೆ ಮೊನ್ನೆ ಎಲ್ಲ 152 ಅಂತ ಹೇಳಿದ್ರು. ಏನೋ ಡೈಲಾಗ್ ನಗಡೋದು ನಗದಿಲ್ಲ ಯಾಕಂದ್ರೆ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗ್ತದೆ.